May I have your lordship's kind leave to mention, my lord? Well, it's item number 70 in today's list. My lord, actually, it is a matter in which I am the respondent. And I'm the respondent. But I am sufferer in this sense, my lord. There is an order of the Central Administrative Tribunal against which the Union of India thought that they are aggrieved. So they have just filed the application, and that interim order is continuing, which is really affecting me. And they are not coming to mention.
Interim order passed by?
Well, later, my lord,
Interim order passed
for
by?
promotion. For promotion.
Interim order passed by?
Yes.
Passed by tribunal.
Passed by the Central Administrative Tribunal.
In your favor?
Yes, CAT.
So you are happy, there is no interim order here.
Let it be, my lord, given some precedence.
Let us see, because I do not know. This file goes to my chamber just to find out whether there is any urgency or not.
So I place it, my lord.
Give it, give all the slips. Let us see. If there is an urgency, we'll allow. Otherwise, give all the slips. Whatever original site, appellate site, give.
Well, may I be permitted to mention this assigned matter, your lordships? This is an assigned read petition.
Give.
Well, I have
everything.
some urgency, your lordships.
We'll consider, write down the urgency, we'll consider it. Give.
My lord,
Well, may I make one point, your lordships? In terms of the judgment of the Honorable Supreme Court, all transfer matter 10C, section 10C virus is pending before your lordships.
Let us see.
Well, in other matters have been transferred, we see.
Consider, sir, we have been taking all the matters. You are arguing so big. Nowadays, I will restrict the time limit.
And that's due, your lordships.
Correct.
But your lordships,
Give
kindly list it
everything.
tomorrow or day after tomorrow. So
Give, we can't assure you. Give.
my lord, may I kindly be permitted to mention?
And what your losses speak after.
My lord, my case was fixed for hearing last year on 8th of June. But because of some reason, it is an exceptionally urgent case, my lord. I am 67 years old. I am a dismissed IPS officer on no ground at all. I will take only half an hour, my lord, to dispose. Even though the file may look voluminous.
Give the slip. Give the
My
slip.
lord, I had given it last week.
It will appear. Don't worry. You just give.
My lord, my urgency is that I am suffering from all types of diseases related to my old age.
You give every litigant before the court is deserves the equal treatment.
Yes, my lord, your lordship had been kind enough to give me to fix it
So
last
it will
year.
appear. Don't worry. It will appear.
My lord,
Don't
my
worry.
prayer is that kindly.
Give the
I will
slip.
take half an hour, my lord.
Whatever.
Only,
Give
only
the
half
slip.
an hour, my lord.
Give the slip. Yes, call the list.
Interim order, my lord, has to be extended. And my lord, there is two things, my lord. The interim order had to be extended. And
This matter has come up by way of an extension of interim order. This matter is mentioned for extension of interim order. Let the interim order granted earlier be extended for a period of 2 weeks from date or until further order, whichever is earlier. Let this matter be listed in the next week.
my lord, may I only request, my lord, there's another application which I had filed in the second.
Sorry, it will all appear anyhow. Yes.
But it's appearing, my lord, your lordship, your.
So we'll hear out all these matters next week. Let's call the list.
Read petition dismissed.
Yes. Yes, call the next.
Lordships, Thank you. Lord,
Lordship,
I am
in
appearing
this
for the
matter,
respondent. I have mentioned this matter, my lord.
Lordship,
My lord, it is a matter, my lord.
Lordship,
uh,
in this matter,
state-
Mr.
state of
Thor is
applicant
appearing.
petitioner.
Lordship, Mr. Thor is appearing in this matter in item number 2 for pro forma respondent and in item number 3 for the petitioners. He has lost his mother today morning. I'm seeking,
He,
he has lost his mother
Oh.
today morning, so I'm seeking fortnight's time.
yes. Unusual circumstances, you can't stand in the way.
Lordship.
Yes.
Okay, I am appearing for the respondent number 1 to 4.
It is submitted on behalf of, what is his name?
Mr. Pratik Dhar.
It is submitted on behalf of Mr. Pratik Dhar,
Yes.
London senior advocate,
Yes.
appearing in
Item number 2 for pro forma respondents and item number 3 for the
appearing in
petition.
the in the matter that he has lost his mother today. Stop. In view of the above, let this matter be listed after fortnight,
Yes.
for 12 days.
Yes. Your Lordship.
Next.
Okay.
Unfortunately.
Never.
Lord, I, my lord, beg to appear for the respondent number 3 to 15. This matter, my lord, pertains to
For the respondent number 1
on the last occasion, my lord, directed Mr. Ghosh, my lord, to visit the premises and find out, my lord,
Yes, a special officer was appointed.
Yes.
Since they were renovating.
No, next second. One. টাকা পয়সা কিছু number 1
So those two car parking spaces also which are not. So it's also that is very areas.
পেছনে
One another proprietor. She's also there. She's also saying rates are not started. It's going to be less and less. There are two entity corporations. It's not very clear with these guys. You have to ask them and then open. He wants to look at this way. Do some of the- the full balance. So put that one right. Start. This is the first row. That's it.
This is under their lock and key.
No. Front, so this opens direction to the left. So I can lock it, open it, and I have no access guys behind. Only four of my head, my access, my ingress, my access. And all other three gates are common. So from one common access is not hidden. This is the text. So this is the old petition number 1, 2, 3, 4. So, this is my which I put for my third info. So first floor, second floor, flat. All the wooden floor.
But before Milord, Mr. Chatterjee, Milord, make
You are
the
for?
submission, I have Milord a preliminary objection.
You are for
3 to 15. 3 to 15. Respondent number 3 to 15. The Milord,
who
owners of the remaining portion of the building.
I am asking you, sir, remaining portions don't say you are the owner of a third floor.
But he's probably
Milord, I
representing.
represent.
I am asking you, you are representing Suman Labels, DSG Road Lines Private Limited, Bengani Jewelers Private Limited,
Yes.
Kanoi Plantation,
Yes.
Pig Iron
Yes.
Supplying, and P. Burley and Associates.
Milord, Varun Mercantiles.
Yes,
Varun Mercantiles.
Varun
Respondent number
Mercantiles
50.
does not appear here,
Fine.
does not appear.
Lord, they have a showroom in the ground floor.
There is one showroom which was under lock and key, which is named as, this is
That's a
Big
restaurant.
Fat Billy. That is closed.
Yes. Lord, I have a preliminary objection with respect to, Lord, the maintainability of this proceeding against my clients. Kindly consider, Lord, this
the initiation of this proceeding is based on an arbitration agreement where I was not a party even. But my question to myself is, my lord, how can a section 9 court or my lord, section 9 be invoked against a non-party to an arbitration agreement who have a separate and distinct claim over the property? Kindly, my lord, comes to
Judgment গুলো কোথায় আছে?
Against third parties.
So just one more.
my lord, kindly comes to the development agreement once, page 55.
Are you not claiming through a developer?
Lord, I am a owner of the property. I have a separate and distinct right.
Through
Lord, that
whom?
is,
Through
specifically
whom?
my submission.
Through whom?
But through him, through the developer.
Ah.
Once Lord, the development is over, once the development work is over, I stand on
If
my.
there is a dispute as to the clauses in the development agreement, and if the proceeding is initiated, then what is the law on the subject?
Lord, kindly comes to the clauses which my learned senior friend has Lord sought to invoke to section 9. Kindly comes Lord to Lord once.
Yes.
Starts from page 55.
Yes.
Party clothing dispute.
Yes.
Kindly comes to page 66 for it.
Yes.
This is the owner's allocation. 40%,
Yes.
I'm sorry, 52%. Thereafter, third and fourth floor. On the second floor, they will have one flat consisting of one bedroom, balcony, and toilet. And third, 7 car parking spaces. So, Lord, the remaining common areas all are Lord, common areas.
So those are required to be preserved. Those are required to be preserved. Now it appears their allegation is that it was an obligation of the developer to maintain the facilities and amenities under the development agreement.
And
Their
to form
allegation
the
is that
association, my lord,
their allegation is that this developer, in connivance with his representatives or the persons claiming through him, they have of their own done many things which is in contravention to the clauses of the agreement. And if that being the position, can he not invoke or enforce the clause of the agreement that this cannot be done?
Respondent number 4 and 8 do not claim from developer. Respondent number 4 and 8 do not claim from developer. They are
They claim-
purchasers from owner's allocation.
doesn't matter.
They are purchasers from owner's allocation.
Correct?
Now, the question is acting as an agent and not standing on his own footing.
Who is the purchaser? One lady, the name of one lady is there. She is through you.
Original owner,
I am asking the lady, that is what is a Suman, what is that name? Agarwal.
Suman Agarwal.
Is whether she has purchased from your allocation.
not a party. Not a party.
I am asking.
Suman Agarwal আমাদের থেকে কিনা? From us.
Not other owners, I'm sorry, not other flat owners are not even parties. If
Cannot
that is the blood stand of the applicant.
I do not know. The position is that there is an allegation against the developer that he is joining hands with the other unit holders and then he is doing all these things. If you come to page 65, clause 8.3. As and from the date of service of notice of possession, kindly visualize. The owner shall also be responsible to pay and bear and shall pay to the developer the service charges for the common facilities of the building payable in respect of the owner's allocation 52% and the management of the common facilities renovation, replacement, repair and maintenance charges, and an expenses for electrical and mechanical equipments, transformer, generator, electrical, mechanical, and other such and such, and other common facilities for that. So it is a developer's obligation to maintain it. If he does not maintain it, and if he has said that somebody else will maintain it, it is somebody who is under an authority of the developer is doing that.
May I answer?
And if the developer, if there is any objection, it's the developer who is responsible.
Try and answer.
So we can injunct that the developer will take over the entire
Yes,
management affairs, everything with the developer under this agreement,
I'm agreeable.
and then do it.
There is no allegation. There is no allegation.
Allegation against the developer. There is no allegation against the
The
developer.
entire allegation is against it.
Developer.
Entire allegation is against it.
May I try and clarify, my lord? There is no allegation coming from the appellant that the developer has handed over the maintenance.
This is what my last order also records.
Kindly see, that's not subject to correction. my lord.
Please, section 9, please show us.
Kindly see section 9, your lordship would find page 336.
And also come to section 60, page 69. Sorry, I omitted to refer. Please come to page 69. Clause 12.6.
That's the main thing.
The developer shall, in consultation with the owner and with his approval, frame the rules and regulation regarding the use, rendition of the common service. All the restrictions have been normally kept.
Let the arbitration commence and continue with the developer.
But
How are we not added as a party?
No, that's not the law.
We are not claiming as
That's
agent
not
of developers.
That's not the law.
law has changed by passage. What you say is the archaic principles at one point of time.
That's
It
not
has developed gradually. Now, there has been a lot of debates.
But whatever the debates are with respect to Bombay High Court, there is no Supreme Court.
It's not a
judgment
Supreme Court
against
judgment also, because the latest one is a Cox and King judgment, where certain principles have been laid down based upon the earlier judgment of the Supreme Court.
it.
It's not.
The principle in all the judgments is not that if the question is whether the person, the third party, is claiming to be an agent or
It is what they are saying, that you are claiming through the developer, because all your rights emanate through. That's an allegation. Let the allegation be substantiated.
But your lordship is adjudicating at an.
Sorry,
arbitration
let us
stage.
see. And where is the arbitration clause? Where is an arbitration clause?
71.
71, 14.1. In case, may I place it for your lordship, lord?
It's 100.
Concerning this agreement. So anything which really popped up from
From this agreement.
it has to be, because it is very expensive.
Lord, kindly sees, Lord, in
Has
case of any
expanded.
dispute, differences, questions arising between the parties.
True, that's the owner and the developer.
Interpretation, meaning and or scope, Lord, in such a case, that will be, Lord, that will be subject to correction. Lord, kindly do not take me amiss. It will create a chaotic situation. I and the owner,
Then
will not enter into an agreement for arbitration. A third party will be a purchaser, but automatically will bind himself for the arbitration clause, because there is an arbitration clause in the developer's
It's a part of your deed.
these
Can't
are
they have a look at
under the
92?
tenders, under the contracts, sir. Everything is there. There may
the
be a
question
special
is-
contract for a particular between the particular party. But there is a general terms and conditions which embodied within itself the arbitration.
Very
And
good.
Lord,
Kindly
If
take
you are
some-
governed by a general terms and conditions as well, you can't say that I have a special contract now and therefore it does not. If the special contract says that there's general terms and conditions apart from
But
that.
subject to correction, this is the difference. There is a difference between a contract, regular contract.
Sorry,
and a
show us the
contract.
law, show us the law. Let us, you are taking a preliminary objection.
Yes.
Show us the law.
Very.
Straight away.
And Lord, kindly marks, Lord, at page 92, the development agreement, Lord, is a part of his deed.
And I have seen somewhere, that's why I was asking. I have seen, let him say.
First, my lord, may I place the provision, my lord, from the Arbitration Conciliation Act?
Yes. Mr. Kormukar has A lot of things to say. Let us understand the law from him. Don't show us the judgment.
Kindly, my lord, comes to page, section 7.
I have seen that. There is no quarrel
Wait.
that is there in our mind.
No, this is 2009, volume 1 SCC.
What the agreement means. After 2009, very big changes have come, sir.
I do agree. There is no quarrel on that, my lord, but the basic principle remains the same.
Let us
That
see.
only
Let
if
us see,
The
sir.
third party is claiming through.
Let us see. Let us see.
Kindly, my lord, comes to the relevant portions as paragraph 7 to 10. 2009, volume 1 SCC 372. This was a dispute arising from section 8.
Just 1 minute.
এটাকে সরান।
Yes, you are referring paragraph 7.
So this was dealing, paragraph 4, my lord, this was dealing with who
I
are
understand.
necessary parties.
Please, you are concerned with
Section
paragraph 7 and 8.
The fundamental lacuna in claiming of the defendants for reference to arbitration is the absence of an arbitration agreement between the parties in regard to the suit transactions. The 3 invoices containing a provision for arbitration relied upon by the petitioner such and such do not relate to the suit transactions at all. The plaintiff, as noticed above, filed a suit for recovery of the amounts allegedly due in regard to some samples supplied by him to the defendants and certain supplies made to the nominees of the first defendant company.
Correct.
The 3 invoices relied on by the defendants, on the other hand, relate to the sale of goods by proprietary concern of the second defendant to the plaintiff. The said invoices have nothing to do with the suit transaction.
Because any
Ah.
transaction which is beyond that particular terms.
Now, not here.
But now it is, that is what I'm saying.
But
It
here
is a
also.
transaction relating to the maintenance of the, let us see, the act relating to maintenance of the common facilities and amenities, which is the
That's the
liability
default of
or
the-
the
that's the default of the
responsibility of the developer. Now, which is
That's
the
the default of the
responsibility and the developer.
Fine.
Now, their allegation is against the developer,
Yes.
that the developer has done all these acts
Yes.
and just tried to frustrate this agreement.
Yes.
Now, if that being the position, will not court,
But not frustrate the agreement because everything has been said and done. Third party
So,
interest has been
can
created,
it not
property
be done?
sold.
Can it
It's
not?
complete.
Then what is the utility? Please look at the language which I say, even after the service of notice of
Yes.
position,
Yes.
it says,
Only to that extent with respect to
"Ore,
maintenance.
after when the property is sold, the service of, I mean, the position is already handed over. Even thereafter the responsibility.
So, my lord,
What more?
here the default is only with the developer and not beyond that.
So that is what when the developer, yes.
Come together and
Yes.
form their own
And it
association.
appears that the third part, their allegation is with the help of the developer.
Now, if
Come
that
to
is
the section 9,
can that
come to
allegation-
section 9,
But
show
my
us.
question is, can that allegation be, my lord, decided at an ad interim stage without affidavits?
Then no ad interim order can be passed.
That
Under any circumstances, Mr. Karmakar,
need not.
if the allegation is to be substantiated after affording an opportunity, then
Yes.
there is no concept of passing an ex parte ad interim order. Even
But
order
is-
39
but
rule
may I-
3
Lord,
has to be rewritten,
ask this question to
has to be
myself.
rewritten.
How the regards of Order 39 Rule 3 has been, my lord, sought to be bypassed by this Section 9 application.
Whatever
How
is there,
the
let us look at that particular allegation.
Page
Anyhow,
340.
that's preliminary objection we will hear. It is relating to a facts, not relating to a law. They have a right to make their submissions first.
Kindly turns to my lord, page 345.
3,
Lord, the section 9 starts off, my lord, from 336 kindly turns to below 345, paragraph 22 onwards. Lord, if your lordship reading, I will read for your lordship, Lord. Based on such premises,
340,
345, paragraph 22, my lord, of my section 9 application. Based on such premises, on 24th May 2022, the respondent number 2 unilaterally decided and purportedly framed rules,
who
regulations.
is the respondent number 2?
Develop.
Developer. Yes.
Unilaterally decided and purported framed rules, regulations, bylaws in respect of the management of the common areas, services of the said premises, and also purportedly constituted respondent number 3 as the holding organization or the association responsible for providing service of maintenance, upkeep, safety and security in the said premises, and for such purposes also executed an agreement between all the occupiers of the said premises, including respondent numbers 4, 8, 10.
Where is that
13,
L?
entire,
Where is that agreement? L?
my lord, your lordship will find that 243. And kindly sees the signatory
240. Just 1 minute.
My lord.
252, sir.
Where is the developer signature?
No, developer signature is not there.
Oh, dude. That is smile may be temporary, not perennial.
Well,
one.
what they've done is they
Let me
formed a,
understand. So there is the respondent number 2 is not a signatory here.
not a signatory yet. What
Right.
we say, my lord, is that he is the one who has handed over it to them.
Let us see.
Yes.
Where, what
it tells you
it says,
252.
any clue from there?
Kindly sees 252. And then kindly sees 300. The letter from him, rather
300?
from the association. 300.
His company
Kindly sees 300. That's the company, Sunny Technologies.
owned by the developer. We have handed over the management of the building.
And then sees, because we complained there was,
This is to whom?
this is my lord to me,
This petitioner number 2.
Rowena Mehrotra,
Yes.
from the developer, saying we have handed over the management of
From the
building.
developer, who is this Sunny Technologies Private?
Yes, that's the company of Jointo Chatterjee.
Means,
Company, my lord, of the developer.
say
And the
that.
signature, my lord, is of Jointo Chatterjee, chairman.
Correct.
Kindly see at the
Correct.
bottom. Kindly sees, my lord, we have handed over the management of the building, Sunny Corner. This is where, my lord, the nexus comes in.
Yes.
To Sunny Corner Owners Association at their request, as we were unable to carry out the essential services owing to non-payment of maintenance charges by most of the residents, not me, including
No, including your father.
Yes, yes.
You also.
yes, father, mother, and yourself. While handing over the management of the building to the Owners Association, we had also handed over to them a list of the payments outstanding from various owners to us. My lord, we are ready to pay to him. We have no problems at all. We have no problems. Take it from me that we are ready to pay to him. Form the association in the correct manner in terms of 12.6. Let the association function. We have got no quarrels at all. My lord, if your lordship sees 240, 252, the signatory is there, my lord. Varun Mercantile did not sign. Myself did not sign. And if I don't sign, my lord, the association cannot be formed. And that's 12.6, which was, I bow down to your lordship, my lord, your lordship was pleased to point out. So the nexus is out in the open. At the ad interim stage, there is no dispute at all. And I'm sure my learned senior friend, my lord, will not dispute that this letter is not sent by him. My lord, what happens is, by this association, what they are forming is, my lord, a group of persons who can collectively come and disturb, my lord, my possession and my enjoyment of the premises. This is what is happening. And they will show a legality to it. And my lord, disturb, my lord, there are 3 my lord, ladies, my lord, who live in that premises. The others are all using them in commercially, which they cannot. And what they want
That is a separate issue. If
also
they have
part
done
of
it,
it, but I will
you
take
can
it up.
take
Yes, I
a
bow
step
down.
somewhere else
I bow down.
that cannot come under section.
But I bow
That's
down
not-
to that. That is not something really under section 9. But the formation of the association is directly under the arbitration, my lord, agreement. That's the most important part. And I'm saying this, my lord, to show the prejudice that's happening, my lord, after formation of that illegal correction. Now, what happens is today the electricity bill is in the name of the promoter. Even today, he is not paying them. And my lord, the blame is on us that look here, it's not being paid. I am saying I am ready to pay to the promoter right now. Today. No, kindly have a look at page 253. Have a look at 253.
Yes.
Kindly see whose name, my lord, joined the
Yes.
charity.
Yes.
Everything, my lord, is in the name of the promoter. He is not paying. We file a supplementary affidavit, my lord.
Taken instructions, my lord, as on date, the bills have been cleared.
Kindly have a look at page
No,
six.
that's the third party who has cleared it.
Yes.
What he says is that the promoter has not paid it.
Lord, I do not have.
That is what his grievance is.
My lord, I don't think what Mr.
Nuances.
Karmakar is saying is correct. Have a look at my supplementary affidavit.
Yes.
This is a bill of February 2023, my lord. It's still today, it's in the name of, my lord, John Charity.
No, that is
Unpaid
what
bill.
is admitted.
Unpaid bill and a notice of disconnect.
Where do I get it?
Page 5, my lord.
Supplementary affidavit page.
5.
The two supplementary.
Page 5 is only photographs.
No.
Other one. The other.
This is, my lord,
The
the
21st,
supplementary affidavit.
21st April 2023 letter.
No, my lord. This is the
That's the
supplementary
Paliganj
for
police
13th
station.
13th April.
Oh, this is the supplementary. Oh, this is the supplementary affidavit.
No, there is not. There are two, my lord, if I'm not mistaken.
One is 13th.
It was Judge Sahib ke din na.
No, there is only one supplementary affidavit.
13th April, my lord, 2023.
এটা তো দেখছি কিন্তু এখানে একটা ফটোগ্রাফস আছে আর একটা লেটার আছে টু দ্য অফিশিয়াল সাপ্লিমেন্টারি দেখতে আচ্ছা ঠিক
My
আছে
lord,
একটা পেজ
I'm grateful. Kindly see page 5 of that supplementary affidavit.
yes
Still in the name of Jointo Chatterjee, notice of disconnection,
green color
green color, notice of disconnection. And this is from where, my lord, that the lift functions. My mother, my lord, is 86 years old. She lives, my lord, in the 4th floor. This is the way, my lord, the pressure is being
this
put.
might
my
have been paid subsequently whatever
lord, subject to correction, my lord, I've got nothing on record to show that it's paid. Not even a submission, my lord, made vociferously that it has been paid. This is what my problem. I'm ready to pay.
Exactly why an affidavit is required.
There we
That
go.
is exactly the,
There
to
we
deal
go.
with these
There we go.
allegations.
There we go.
That's the reason why the learned trial judge
how can
rightly.
you do that will not hear you why you will do that your obligation was to form an association.
But what I am submitting is this, my lord, that because of non-payment of the monthly maintenance charges by different unit holders,
Yes.
my lord, at one stage, I become fed up and 5,000 rupees, 50,000 rupees is now outstanding. I left the premises by handing over the possession of the management of the building.
Whom? How? You can do it under the clause in consultation with the owner. Did you consult the owner?
Disputing.
Then
I had a talk with, before I hand over and formation of the association, I had a talk with the original owner, Ajay Bush. My lord, with his consent, the association was there. But rightly, wrongly, my lord, may I tell your lordship, if it honest your lordship, my landed client is having several allegations against the present association. My lord, kindly, my lord, the problem can be solved if a new association is formed with the suggestion of my appellant and the present flat owners, my lord. If they form an association, my lord, I can hand over the maintenance, day-to-day maintenance to the association.
So they agree, but it's illegal. Formation of
Uh-huh,
one,
don't-
I don't have a problem.
They
I'll just take instruction.
that's a very fair suggestion that has come.
Absolutely.
They made 1,000 allegations against the developer. I am not trying to escape my responsibility.
Just gives me
But
1 minute's
being
time.
disgusted, I left the premises, my lord, because of non-payment of the maintenance charges. I cannot pay the maintenance charges from my own pocket. The electricity bill, which was standing in my name because the meter was installed at my instance as a developer. Now, there is also, I paid over the possession of the meter and as well as the monthly electricity charges to the association. Now they are going on making payment or not, I do not know. from April
Everybody will sit and
2022,
find out.
I have left the premises. He discussed it. If
We don't have a problem. We don't have a problem. Let everybody sit together.
But if your lordship, if it is comments to your lordship, my lord, for regularization of the maintenance of the building, my client can take over the chart, but subject to formation of the association immediately, my lord, through intervention of the court, matter will be solved.
We are also agreeable to that. We are
Very well.
also agreeable to that.
Very well.
Let
I
them
cannot
contribute,
give a
let them
permanent
contribute.
Developer for permanent
solved.
maintenance.
Think of it,
ভাই, association তৈরি করে নাও এখানে।
think of it.
Raji,
Think
I am
of it.
agreeable.
I think because of these allegations, it's a suggestion. It is definitely not an imposition on any of the parties. It's simplicity or a suggestion, whether acceptable, not acceptable, nothing of that kind. Free, you are free. What I say is, he's absolutely right. You all have agreed on that yes, we'll sit together and form association to do it. There is another allegation which has come out that many of them are defaulters in payment of the maintenance charges. Can we not think of it? Can we not do one thing, that there is some amount which is to be kept as a security for each of the unit holders? That in the event of any default having committed for the time being, at least that amount can be taken away and can be utilized.
So that
Because
was one of the
because
clause.
he did not have to wait. Sometimes it may come late, sometimes it so happened. Nowadays, the economic stress,
Yes.
the problems may arise for a month or a two.
But
At least that
Big Fat
person
Belly is closed.
is not deprived of whatever that he is entitled if the money is already lying. Just think of it. I just think that will solve, because he says so much of outstanding, disgusted, and then we out of frustration we went out. So
Sir,
that is
I'm
what is
surprised-
allegation. If everybody, unit holders think,
Sufficient.
if they can sit together, that can be done and kept as a reserves in the
Absolutely ready.
All of
association.
us are agreeable.
May that association form through intervention of the court.
Yes, kindly appoint a special officer, a special officer, somebody responsible who will, my lord, who has some, my lord, experience in this. I have no problem. Yes, yes, absolutely, absolutely. I have got no problems.
There is
who
no
will
question of any special officer. It is-
No,
it is a
No, they will be
No,
doing
no,
the
that-
bargaining power.
he will be just convening all these meetings
Yes.
with all of
Not
them.
the formalities with
And,
respect to the
and
apartment
then
ownership
you will
is also
discuss.
compliant.
He is there just to convene.
Yes.
I suggest one thing, Mr. That is here. We have full faith and confidence on him. Let us hold a meeting, my lord, in presence of the parties, my lord. Let them form an association.
But I cannot dispute to that.
Don't put any of the appearing councils. Don't put any of the
Exactly.
councils in an embarrassing situation.
Thank you.
Because you may be very fair, but you don't know. You don't have a control over the party.
Millard, in one matter, I was engaged as an arbitrator, and I'm facing hell in that. Because somebody says, Millard, that the arbitration agreement is a matter of fraud. He's gone and filed a criminal case against me. I am the arbitrator. Kindly imagine my plight. Imagine my plight.
And
I
the
am the
mandate has been
arbitrator.
terminated.
And I have terminated the mandate, but he has gone and filed, Millard, a criminal case against me, saying that I have connived in filing, Millard, this arbitration process. After that, I have just washed my hands off for everything of this nature. I have terminated the arbitration proceeding, saying that the claimant doesn't even come for the arbitration. And look at me on my plight. I am going and explaining people, look here, I am not a thief. I have terminated the arbitration agreement because they did not come to me.
My lord, if-
This is where I am, my lord.
if a
So,
proper
I am not getting into this at all. Simple lawyer, my lord, will do my cases, go back home.
But subject to what falls from your lordship, Lord, this matter can be sent for mediation, that can be taken.
No, that will take a lot of time.
form can-
Just 8,500 rupees is the due. Seize it. And there are 50 people who are doing, my lord, business out of there. And my learned senior, not my learned senior friend, my learned friend says, my lord, that they can't put in 8,500 rupees. They are earning, my lord. I don't know what from.
Why don't he there? He let him
Yes.
convene the meeting. Why you are afraid of?
Give a direction, my lord.
Yes.
For the purpose of formation of the association, my lord.
Oh, he will convene the meeting. He will be a convener. convener of the meeting, and in his presence, everything will be sorted out. What is the difficulty? A third. Lakho. The endless allegations and counter allegations started when the report is submitted by the special officer indicating the extent of actual affairs prevalent at the site in question. Full stop. The parties are not ad idem on a common issue and taking all sorts of pleas which would ultimately forestall the progress in pursuit of a final relief to be granted in the proceedings. However, during interaction and the queries being raised in course of the hearing, all the learned counsels representing the respective parties, on instructions received from a person authorized this in this regard and present in court.
No, my clients are present in.
Submit that the possible solution which can be done in the instant, which can be done in such scenario, is that the developer who prima facie appears to have been entrusted with the responsibility of maintaining the common facilities and amenities at the constructed building shall act in terms of the clause contained in the development agreement in formation of an association and thereafter the management and the administration of the building can be entrusted upon the said association. Such suggestion appears to be fair as it would take care of the impasse having been created between the parties. Stop. We feel that in order to bring all the parties on a common platform, the special officer should be entrusted a responsibility of convening a meetings of the respective parties for the purpose of arriving at the common purpose of formation of an association. If the parties at all agreed and accepted the accepted the same. We do not intend to dispose of the proceeding at this juncture, having seen a ray of hope and a beam of light in the darkness of the disputes prevalent between the parties. and therefore kept the matter pending before us. The special officer is directed to convene a meeting of the parties at the site, at the subject site, and an outcome thereof shall be communicated to this court in the form of a report. Let this matter be listed 2 weeks after the reopening of this court following the summer vacation.
Lord, my respectful submission.
Special officer might not hold that meeting, might not within a stipulated period.
He's a very Mr. Counsel, I do not know whether you know him personally or not. He appears to be a very responsible person of the member of the bar.
And he knows.
I
his-
never found him agitating,
Yes.
as the other lawyers say, sometimes losing temper, losing cool. He has a smiling face, always smiling. I think is
Before this part.
Lord, what I was
It
praying.
is done before this.
No, sit down.
no, you
No.
do it. I have just kept it.
Lord, what
In
I was praying.
anticipation that in one day, kindly visualize, sir, in one day, these kind of a things may not
Happened.
come. That it's ended.
Milord,
It may take 1, 2, 3 meetings between the parties. Somebody may not be available on that day. Somebody will say on that day, I want. So all these things I have taken care of. And then I think
Possibly is keeping it 2 weeks after the.
2 weeks after the puja.
No, I'm always, Lord, smiling. Always, Lord, I'm never agitated. Lord, your lordship has never seen me agitated.
I have just simply generalized these situations. But it is not that somebody may not lose cool. Somebody sometimes lose cool. And you are not an exception to it.
Those are aberrations. Similarly, my lord, goes for my lord as well. Never seen my lord agitated at times. Grateful to Lordship, extremely grateful. my lord. But I'm a little surprised, my lord. Big Fat Valley, my lord, is closed. I am.
Is a time for zero figure.
Now, if the belly is big fat, you can't.
I'm not too happy with that, my lord. It should be open.
I think that will take care of everybody's belly
I
there.
guess so. Yes.
But it- as because everybody has taken care of that restaurant, the restaurant has stopped the. My taking care.
It's actually, you know, the owners have come down from the top and have eaten so much there, my lord, without paying. Gone.
Lord, I have brought, Lord, the Central Civil Services Temporary Services Rules 1965. The 2 copies I am.
Oh, sorry. এই আগের ম্যাটারের রিপোর্টটা রেখে এই উপরে লিখেছি প্রথমে the special officer submitted the report which is kept উপরে লিখে দিয়েছো তো? করে দেবো। What is can we recapitulate the facts?
This is that matter regarding the. My application.
Anyhow, don't worry. He is not going to prejudice the mind. Don't worry. Just to recapitulate, we will recapitulate everything. Yes.
On the last occasion, I have.
What is the? Yes,
uh,
yes, last occasion.
Regarding the probationer, during the probation, termination order has been issued.
Oh, yes.
And they have
You say temporary employee?
temporary employment, but I am a probationer. As per appointment order, I am a probationer. And before that, they have conducted.
Stigma, continuing
Stigma.
this is what is there.
Stigma.
Something more was found from you.
Yes. And they have plain termination order has been made. There are 2 decisions I have cited. One is a constitution based decision of
Let us see. I have
Samsesi.
seen that. I have seen- Yes,
Lord.
yes, sir.
Here,
What is?
Lord,
the judgment which has been cited, my lord.
No, first tell us what is
Here,
this?
here, my lord. My lord, here kindly have a look, my lord. The
I think a portion of the rule was,
yes,
and then he handed over a very small,
Handed over.
my lord, kindly have a
that
look.
is one small
TS
book.
rules.
Yes. So we wanted the
My lord,
photocopy.
here the rule 5. It's very, my lord.
I have
this is
given the Xerox copy.
from, my lord, this is the Dr. Awasthi's book, my lord, commentary. Here, my lord, the rule 5 at page, my lord, 755, termination of temporary service. 1A, the service of a temporary government servant shall be liable to termination at any time by a notice in
Is holding a temporary service or what? The temporary service has been defined in the rules itself. If you come to the definition of a temporary service, incidentally or accidentally I have come across, please come to rule 2D, what it says. Same rule. Temporary service means service of a temporary government servant in a temporary post first. He is not holding a temporary post. Is it true? He's not holding a temporary post. And he is not a temporary government servant in that sense. Correct? Then, or it goes further, or officiating service in a permanent post. So this is definitely a permanent post which he was holding. Now, one has to understand, was it an officiating service or it was a full-fledged regular service it was given?
he is a ex-serviceman. He is
I am
a
again, sir, if you have to apply these rules, then this rule, the definition of the rule has to be understood. And this is in relation to a temporary service. And the temporary service is defined. If a statute has defined a particular expression or a word, then wherever that expression appears in the statute or the subordinate legislation, it is only that meaning which has to be assigned. And you cannot borrow an external aid, nor you can borrow a dictionary meaning, nor you can borrow a generic meaning. You have to restrict to that meaning which has been defined, given in the act itself. If the service, temporary service is defined, and he is not holding a temporary post, or if he is not officiating a permanent post, then he does not come under the purview of this particular rules. Then he is kept outside the purview of these rules.
He is governed by the appointment letter.
Sir, then sir, that the situation would be that there is no governing rule. Let us go. If he is kept outside the purview of this, then there is no governing rules. Then what? They will be governed by a terms and conditions embodied in the letter of appointment as well.
That is, my lord, page 21.
Yes.
Page
No, first answer this. You have taken shelter. They have taken shelter under these rules or not? Or you have
Yeah,
taken shelter?
I am taking the plea. The rule which they have quoted in my order, this is not applicable. The clear I have stated. And
So if you have taken a shelter under these rules, then you have to satisfy us that this rule applies.
My lord, I have said it in paragraph 4 of the appointment letter.
No,
while
Mr. Dolia, please do not digress. What your authority says, you are bound to mention that. May I remind you of that particular off-quoted judgment of the Supreme Court in MS Gill? That member of the bar cannot improve a case which the authority have not done.
In the appointment letter,
I am asking you, in your decision of termination, Did you take shelter under these rules? I'm asking you a very specific question.
I go by this appointment letter, my lord.
What your authority, sir? You are representing an authority. You are supporting their decision. Please tell us what your authority have taken a stand.
Page 48, under
Yes, my lord.
CCSTS rules, page 48, can you see? In persons of sub-rule 1 of rule 5 of the civil service.
So you have taken a steps. You have taken shelter under these rules. Tell us whether this rule applies.
My lord, the
You have to first satisfy.
Lord, kindly have a look, my lord, at the page 21. That is the appointment letter, my lord. What I have said in the appointment letter, my lord. I read, may I read, my lord? Here, my lord, the such and such hereby appointed as civil motor driver, Group C at Army Recruiting Office, Gopalpur, under Headquarter Recruiting Zone, Kolkata, with effect from 1st December 2017. Please report at Headquarter Recruiting Zone, Kolkata by 10 hours, 1st December 2017. Last date in time, reporting is 12 hours on 10 December 2017. Then paragraph 2, my lord. Initially, you will be on probation for a period of 2
Mr.
years.
Trolia, we are not at all questioning that, sir. He is a probationer. At any time during the period of probation, you can say, I do not want you. Throw him out. You can do so. There is no difficulty. What is the concept of this probation? What is the concept? Because yes, you have been found suitable for this post, but let us see your performance in that particular position. If your performance is not up to the standards which has been set, then the authorities are not bound to carry this dedur for all time to come. The authorities may say, I do not want you. Go, no problem. No problem. But the moment you have indicated a particular rule and say that you have been terminated on this, then first and foremost thing is you have to satisfy whether these rules apply.
Then it will not apply, my lord.
If rules apply,
Not apply.
if it does not apply, will your action be not impinged because you have taken a wrong path?
Yeah.
You have taken a wrong path.
Although the word temporary has been used in the appointment letter in paragraph 2.
No, temporary will not do because the temporary service, it is the rules relating to temporary service.
My lord.
So you must satisfy that he satisfies the definition of a temporary service.
Yes, but the
He
definition
was
of
not
the-
appointed at the temporary post. It was a permanent post, I believe.
This is the permanent post.
Correct.
This is permanent.
So the first category of the definition goes. The second category of the definition is officiating service in a permanent post. What is this meaning of, what is the meaning of this expression? I just wanted to know from you.
He is not officiating in his permanent post.
So if he is not coming either of these two situations, then he does not satisfy the definition of temporary service. If it does not, then whether rule 5A applies? Tell me. If it does not apply, then the termination taking aid under 5.1 has to go. Has to go.
Here action is taken, my lord, in terms of the appointment letter. Appointment
Not,
letter.
sir, that is what you are saying at the bar. If you come to page 40, he just drew our attention to it. Come to page 48. What your authority, I mean, Mr. That is a brigadier. Mr. Rana has said that in pursuance of sub-rule 1 of rule 5 of the Central Civil Service Temporary Service Rules 1965, such and such hereby give a notice to the petitioner that your services shall stand terminated with effect from an expiry of period of 1 month from the date of which the notice is served. So this is what you invoke this provision and you terminated his service under this provision. Then you say that this provision does not apply. If it does not apply, then can it be done? I'm asking you a very simple question, sir.
As far the definition of this, my lord, given, my lord, the definition of this temporary service that provided in the, my lord, the CCS Temporary Services Rule 1965, that, my lord, as per this definition, my lord, it will not fall.
Then
Will
if
not
your
fall.
stand is it does not fall, then how this action can be said to be perfect, legal, justified?
Therefore, my lord, it will not apply. Then I will, my lord, base my, my lord, this, my lord, case, my lord, on the basis of the appointment letter. Appointment letter is, my lord, that is, my lord, look into, my lord, kindly look into page 21. Here, my lord, whatever this is the service agreement. My lord, here.
To have the MS Gill judgment because he is showing ignorance of that judgment of the Supreme Court. Do you have that particular MS Gill judgment? Can you give?
Services.
I think he's pretending ignorance of that. I am not saying putting. It's a pretending ignorance of that.
Here, my lord.
Please give that. First you read the judgment and then argue. Please read the judgment, the spirit of the Supreme Court judgment, and then argue. You are really explaining, you are expanding the case. You are trying to make out a new case for the first time just to justify the decision. Can you do so? That is what I am bringing that judgment. We are bound by the Supreme Court judgment, by Article 141.
Apart from that, my lord, regarding that non-applicability of these rules, my lord, then, my lord, how to deal with the situation, my lord. Here, my lord, the appointment letter is to be.
No difficulty, Mr. Dhulia. Who says that you can't do it? But you have to take a decision, either this or this. If you have taken a recourse that this is the mode, then you have excluded this. Once you fail, then you say, no, consider this. Tell me whether it is permissible.
Moreover, my lord, that the order, my lord, of the traveler, kindly have a look, my lord. Kindly have a look, my lord. Last page of the judgment. Page.
Mr. Dolia, the facts are very ugly, I tell you. The facts as emerge definitely does not invite him to be there. But the law has to be respected.
So what happens, my lord? If in military service, my lord, if anything happens, immediately there is an inquiry set up. This is mandatory. If anything happens in military services, my lord, there will be inquiry set up.
Sir, we are not unaware that in these disciplined services, this is the military service, CISF, BSF, all these services which are the disciplined services, the magnitude of the misconduct is much higher than in relation to any other civil
Entire
services.
nation is affected. Entire nation is affected.
I am at one. We are having this in our mind, sir. It is not that we are not keeping those in our mind. But does it mean that the law has to be ignored in this regard? The law has to be completely overlooked. You are also a creature of a law. Everybody of this country is bound by the law of the country, unless excluded. So this is what I am on. That is what I say.
what was the showing, my lord, to my lord, in the paragraph 7 of the judgment, it is stated that for the ends of justice, termination order is quashed and liberty to the respondent to initiate proceedings against the applicant if found necessary. So liberty is there, my lord.
So why you are aggrieved? Sitting here, we can't assume the advisory jurisdiction. You are there, you know what to do.
And the judgment which has been cited, the 7th bench judgment which is cited, my lord, here, my lord, it is stated that, my lord, if the inquiry is for the sake of inquiry, but not punitive.
I know. But when you place these rules, that is why that troubles me, or us rather.
One SCC, 1978, one SCC, page 405.
Think of, we are coming within 5 minutes. Think of it and tell us.
I have gone through the CCS temporary service rules, my lord. Here, on my mistake, my lord, here, my lord, the definition, which I could not analyze this, my lord. Here, my lord, kindly have a, again, my lord. The definition, my lord, of temporary service. My lord, means the service of a temporary government servant in a temporary post. This will not apply. This will not apply. Then, my lord, or officiating service in a permanent post. So he is officiating in a permanent post, but temporary basis. Till
What is the meaning of officiating?
he is already working on in a permanent post.
What is the meaning of the officiating service? I think service jurisprudence, the officiating service has been in a particular situation.
Stopgap arrangement, stopgap arrangement.
Suppose a person is there in a particular post. There is another post which has fallen vacant, which is a permanent. But the work has to be done because nobody can remain silent on that because there are several duties entrusted to that post. Or it is, I think it is entrusted upon that. If somebody says that you do it, like say the Chief Justice, the post of the Chief Justice has fallen vacant. The senior most judge of the High Court is officiating as a Chief Justice, is discharging the functions of a Chief Justice. Does it mean that he's a Chief Justice in that sense? Because he's officiating. He's not having a permanent position.
Officiating meaning, my lord, that my lord is working in that.
He's really discharging the duties and responsibilities of a post.
Yes.
Of a
Of a
post,
permanent post.
in addition to what he is already discharging his duties to his post, which is there.
That meaning, I don't think so, my lord, that will come here.
In a service jurisprudence, sir, I have a very limited,
Here, my lord,
please tell us.
officiating service means.
Mr.
he's working
Bose,
there.
what is the meaning of this expression? But he's not holding that post in that sense. He must be holding another post. A probationer is appointed to a permanent post, whether he is officiating in a permanent post.
Officiating service
Means
in a permanent.
he is
post.
already having been given a charge of a particular post, but he is also.
Otherwise, the official comes. The meaning thereby, my lord, he is officiating service in a permanent post, his service in a permanent post, and he is working there. So, my lord, this second limb will be operative, my lord, here. And that's why, my lord, after consulting these rules, whatever has been done by the authorities, my lord, in consultation of the rules.
Now, what will happen? Suppose somebody is appointed to a permanent post where somebody is officiating that post. Then he reverts back to his original post. And then the person who comes in that post will discharge the duties. But if you appoint a person to a post as probationer, I have doubts, sir.
Only
If you
one
can
post.
clarify this situation, whether he can be
Only one permanent
put
post.
within that particular bracket of officiating
Here, my lord,
a service in a permanent post.
here the post is, my lord, civil motor driver, permanent post. And
Correct.
my lord, the officiating service in a permanent post. So officiating service, giving service in a permanent post. That is the CMD. So therefore, my lord, second leave.
Does it not connote that he is already a substantive post or a substantive permanent post in a different category than this post, and he has been discharging the duties of that,
In
which
addition,
is
but
in
here is
addition.
not the case.
Correct. So whether he will come under that, he will not come under that. Officiating also.
Officiating, my lord, he is working. So officiating used, my lord, here, he is working in a permanent post. Meaning thereby, my lord, he is working in a permanent post. So therefore, my lord, these rules, my lord,
Simple meanings, I am a probationer. I was appointed against a permanent post. Now 2 years on probation.
Sir, why we are putting so much question is because of that.
So, my lord, let us take, my lord, rules is applicable, my lord. Let us take on that basis, my lord, I will further argue, my lord, my case. So here, my lord, the things which earlier, my lord, your lordship, my lord, we went through, my lord, then this temporary post or a officiating service in a permanent post. So officiating service meant, my lord, in a permanent post, CMD post, permanent post, he is working, officiating service. So here, my lord, this, as per the definition D, my lord, this rules is applicable in case of the applicant. Or your lordship so direct, I may find out, my lord, the meaning of literal meaning from the dictionary, my lord, the Black's dictionary, other dictionary, and will come up before your lordship. Lordship may fix some other day, my lord. I will come.
But
with
I am
that.
opposing in respect of this pair, my lord. The rule is absolutely in favor of the petitioner, number one. Number two, not only rules, what they have done, they made an inquiry before termination, which is totally barred in terms of the decision of the constitutional bench, my lord.
That is otherwise.
Absolutely, my lord. Law is very clear.
I have
Law is well settled, my lord. Law is well settled, my lord. In some sense, in judgment, my lord. Behind the back here, they have done like this. Therefore, this is not only ground, another ground is, my lord.
Don't open so wide. What is your conduct?
Well, that is true, but they have to make a full page inquiry.
What is
Behind
your
the back, they
conduct,
cannot do.
sir? What is your conduct?
Well, that is the rule.
Or you will give the chit to all these aspirants and then
Well,
put it, your phone number. Are you a whistleblower?
this is not fact.
You
I have not done anything.
You are the only person
And not only that, till now, my lord, they
who
did
will
not.
keep everything. And there are serious allegations which you have
My lord,
made.
it is an allegation. It's an allegation.
You have made.
What
You have
that
to
they-
substantiate.
My lord, they made an inquiry. I have to give it an opportunity.
You have grievance against every person on the earth.
My lord, that is the judgment, my lord. Your lordship has read out in the last occasion, my lord.
We will. We are not concerned. We will definitely
place the same
consider that judgment. And what the judgment says, we know
Yes.
what it has said. The only problem which we faced was this, when a rule was there. That's the only problem.
And the saving clause is very clearly stated, my lord, in paragraph 5.
First thing is, if you do not come under this, will you take advantage of the saving some of the provisions and some of the provisions?
Not I am claiming, but
So how can you do it? If you say that, yes, you come within this purview, then consider and interpret.
yes.
If you do not come under that purview, then you can't say that this provision will not apply, this provision will apply. How? With lock, stock and barrel, the entire rules will not be applicable. You can't take advantage of one clause
No,
or
I have taken this
another
point.
clause.
This rule is not applicable. This particular rule is not applicable.
My lord, I will come with a definition of officiating service, my lord. Kindly give me time, my lord. I will come before your lordship. I will explain. I will explain, my lord, on this particular, this word, officiating service. What is the meaning there to, my lord? I will come. Well, kindly grant some time, my lord. I will come.
No, we don't mind, but still, I believe, very difficult.
My lord, the officiating service in a permanent post means, officiating means, my lord, working. My lord, that I will come before lordship, my lord, and the Black's dictionary and others, my lord, dictionary, I will come definitions. And if available, my lord, I will come also some judgment on this issue, my lord.
Yes.
Kindly have a look, my lord. Rule 2A. Here, my lord, where notice is given by the appointing authority, terminating service of a government servant, or where service of any government servant is terminated, either on expiry of the period of such notice or forthwith by payment of pay plus allowances, the central government or any other authority specified by the central government in this behalf may on its own motion otherwise reopen. So here, my lord, the provision of reopen has been provided. Reopen the case, and after calling the records of the case, after making such inquiry as deemed fit, confirm the action taken by the appointing authority, withdraw the notice, reinstate government servant service, make such other order in the case as it may consider proper. So here, my lord, reopen provision is there, and here, my lord, the allegation is there, my lord, that, my lord, the 8 page 81 of the application before the tribunal, my lord, in paragraph 4.13, it is stated that, my lord, that the respondent preferred an
Oh,
appeal.
there is one, I think the office memorandum dated 26 August 1961, as I find from your this
Below.
photocopy,
Below.
which you have handed over, so far as the rules.
Below.
There certain clarification has come. I really wanted whether do you have this copy of this office memorandum?
At one place I found, my lord, that is the government's.
No, that I found. Because there is a, whether the rule 5.1, where you have taken a shelter, applied to a probationer, then this office memorandum, the tenet as it is quoted here, shows that a question has arisen whether this rule should be invoked also in case of a person appointed on probation, wherein the appointment letter a specific condition regarding the termination of service without any notice during or at the end of the period of probation, excluding the extended period, if any, has been provided. The position is, this is here, it really struck my mind. The position is that CCS TS rules do not specifically excludes probationers or persons on probation as such. So the stand of the government is that probationers are also ingrained into it. However, in view of the specific condition regarding the termination of service without any notice, during or at the end of the period of promotion, it has been decided in consultation with the Ministry of Law that in cases where such a provision has been specifically made in the letter of appointment, it would be desirable to terminate the service of the probationer on probation in terms of the letter of appointment and not under Rule 5.1. So you yourself has said 5.1 will not apply in those cases. This is a office memorandum, Government of India, Ministry of Home Affairs, office memorandum number 4/10/66 ESTC dated 26 August 1967. Whether it is still in vogue or it has been superseded.
This is stated, my lord, page number, my lord, at page.
After Rule 5,
Yes, yes. The
Government of India's order,
government of
heading, first one.
Lord, all these things, my lord, I will explain, your lordship, on the next occasion, my lord. I will bring all these, my lord, this government's order.
So when
And-
you come, you should come ready. When you are handing over this document, you must have read this document.
And here
So
also.
why you do not prepare yourself fully in this regard? Whenever the certain questions are put to by the judge, you are saying, let me consider, let me come on the other day. That really just, I say, give an impetus for pendency, nothing more than that. It just gives an impetus to a pendency of the case. You should come ready with all points. You have handed over this document. We don't know. Will you not read this document before you hand over?
One more thing, my lord, kindly have a look, my lord, that bottom, my lord, bottom, regions should not be mentioned in the termination order.
No, I understand. If it is a simpliciter termination under the appointment letter or the conditions signed in the appointment letter, no difficulty. The moment you take shelter under 5.1, then you will have to satisfy. Only one ray of something which I find, one sentence it says, the position is that the CCS TS rules does not specifically exclude probationers. That's the only sentence which really comes in your aid. So is it not necessary to look at this memorandum, office memorandum, under what circumstances? And I also noticed a very interesting thing from the preamble of the rules itself and the definition. If you come to the definition after this temporary service, there is a defense service which is defined. But my cursory look at the provisions, I do not find this particular expression defense service anywhere appearing in the sections, in the rules. I do not find this. Unnecessarily, why the definition of the defense service will come? It has not been used. The defense service word has not been used in any of the
What
rules.
has been used when the defense service has been used in the rules, meaning
No,
thereby.
no. It is defined in section 2E, but thereafter, I do not find in any, either in rule 5, rule 6, rule 9, rule 10, I do not find any word defense service used. But definitely in the preamble and the object, the word defense service is used. Not defense service, but
Exclusion clause is below that is rule sub rule 3, rule 1 of sub rule 3, which will not be.
because I find from rule 1.3 where we find this word. Sorry, I got this word I found. It says, subject to the provision of sub rule 4, these rules shall apply to all persons who hold a civil post, including all civilians paid from the defense service estimates under the government of India, and who are under the rule-making control of the president, but who do not hold a lien or a suspended lien on any post under the government of India. So this is what first time I find this particular expression. And then rule 4 says nothing in this rule shall apply to a railway servants. It will not apply to a government servants in wholesome employment. It will not apply to a government servant engaged on contract, government servant paid out of contingencies, persons employed in extra temporary establishment or in work charges establishment, non-departmental telegraphists and the telegraph man employed in the post of a telegraph department. Such other categories of employee as may be specified by the central government by notification. Nothing.
And this will not the payment who hold a civil post, including all civilians paid from the defense services.
Understand.
Here the payment is made from this.
Correct. I know. That's why I said it is not that you are not coming under that particular rule as a department. This department is bound by these rules. No difficulty. But once you apply the rules, then the conditions given in the rule has to be satisfied. If the conditions are not satisfied, then does it apply to a brigadier? Does it apply to a lieutenant colonel? No.
Civil post in defense.
No. It's a permanent full post. They are not holding a temporary service. Full-fledged, permanent. So it is relatable. That's why I say is only relatable to a temporary services. You can't apply to any other persons who is permanently posted.
Advertisement made as per Milord, the permanent post. Advertisement for recruitment made for the permanent post.
It is only in relation to a temporary service, sir. It is not in relation to the permanent service. So this office memorandum is a very important piece of the document here.
I will try to, Milord, get it all, Milord, from the website, and otherwise I will ask the department to provide me, and I will come before Milord.
Unnecessary. You should come prepared. When you hand over a particular document, you should be ready with all the probable or
Milord is mentioned subject to the provision of sub rule 4. These rules shall apply to all persons. And 4,
I invited your attention, sir. You are getting more enlightened because of us. You have not applied your mind. So you should have read it. It is only when we pointed out certain things, then you are now becoming more wise and then saying all these things. Can you come day after tomorrow ready with this?
this week, Milord, I will not be, Milord.
What problem? Every time if you have a problem, then what can be done?
Milord,
We have already
attended
heard the
marriage.
matter at length. We are ready to dispose of the matter. Unnecessarily is being dragged.
Fix it on 8th, Milord. I will.
Unnecessarily, why? Come. Tomorrow is a commercial matters day. So I can't fix it. Day after tomorrow we are here.
In fact, Milord, for my personal reason, Milord, I will go today, Milord, to attend a marriage at Jaipur, Milord. I will come back on 4th.
Learned advocate for the Union of India submits that he needs to go to go further deep into the matter on the basis of the queries raised by this court in course of the argument, and prayed for listing the matter on the other day. As suggested by him, let this matter be listed on 8th May.
Let it be 9th, Milord.
But night, Milord, I have some problem.
9th is a holiday, sir.
Then, let it be 10th, Milord. 10th, Milord. Because I
Oh,
will
he
be
is bargaining, Milord.
Sunday, Milord, I will make all arrange, Milord, this.
On 10th.
Milord,
Milord, under heading forwarders, Milord. It is happening
Under the same heading.
here, Milord, the sub rule 3, Milord, that says, Milord, subject to the
With
provisions
deepest of respect to you, sir,
all persons.
do not prepare yourself here, because it will invite a further queries from us and you will not be able to answer. Please go into it, comprehend the entire thing, come.
Lord, I appear in this matter for the petitioner. Lord, this is that matter. Your lordship heard this matter, kept it for orders. But at the end of the day, my learned friend appearing for the respondents, state respondents, mentioned the matter, saying that the disciplinary proceeding which was initiated against the petitioner has culminated into the order of dismissal. Now, my lord, thing is this, Lord, the doctor, the petitioner before the learned tribunal, Lord, tendered a resignation.
I understand. Then later on, you
Withdrew-
wanted to contest.
Yes.
the election, you
Yes.
could not succeed there. You wanted to withdraw.
Yes,
The application for withdrawal of the
Yes.
resignation letter was also tendered.
yes,
Thereafter, you wanted to resume duty. They issued an order on the same day. They revoked the order
yes, yes.
of resumption. That's
yes,
there in
yes,
my
yes,
mind.
Yes, yes. Your
But
lordship,
now they say the disciplinary proceeding has culminated into a final order.
yes. Now, the thing is, this minute I pressed for the stay before the tribunal for the reason that they are proceeding with the disciplinary proceeding. Now, the tribunal passed the order, saying that it should be heard by division bench. Otherwise, I could have obtained a stay order. But the tribunal for the failure on the part of the tribunal, learned tribunal, I could not just obtain the interim order.
Now, rightly, wrongly, something has come. Then what to do?
And where no salary has been paid, I have not been paid a salary.
I understand.
Yes.
During those period of suspension or what?
No
During
suspension,
there
nothing.
was no suspension.
Yes.
So,
And from
so
first
these questions,
from 1st May 2021 till date.
now what to do? It's a subsequent event.
But I will definitely challenge this by way of supplementary affidavit before the tribunal.
Now, I do not know. Whatever you want to do it at this stage, what interim order can be passed?
No, your lordship kindly disposes my writ petition.
Yes.
Blood-
And then
Yes, but with a direction that I should be paid my salaries, because my dismissal is dated.
but the difficulty is because they have to file their affidavits here. They have to show their conduct, that why they did not permit you to join.
Yes.
Everything has to be done. Because it will have. What for affidavit? Sorry, you are a petitioner here. Oh, you are not you are a state. You are the respondents. We will simply take on record the order of termination or a dismissal, and then they can go and take action against that. Which they can do.
Only thing, that document, we have filed in the form of an affidavit. So for that document.
Give him a doc-
In certain cases, court can mold the relief. Your lordship kindly consider the method of imposition of penalty is wholly illegal, because your lordship passed the order on 17th on 17th April, directing my learned friend to take instruction from the state. And on 25th, on 24th April, they passed the order.
The order has been passed on 5th of April.
No, and I have been communicated, your lordship
5th of
kindly
April,
see,
the order has been passed.
kindly see, I have been communicated on 28th of this month.
Yes.
When your lordship is in scene of the matter.
But if this communication comes earlier, then I should have apprised to his lordship.
Kindly see, this is a fit case for molding the relief, Lord. I
When
pray
to
for
have
you,
this passed.
I have, that's the, what to do, if on 5th they have come up and say unless and until lordship scrolled them, they should not have, I have doubtful whether I would have this document or not.
Leave is granted to the state to file the affidavits, copy whereof has been served upon the writ petitioner herein. By the said affidavit, the state wanted to disclose the documents relating to the initiation of a disciplinary proceedings, which culminated into an order of termination or removal.
Termination.
Culminated into an
Dismissal
order
from
of-
the service.
জিজ্ঞেস করি, dismissal, removal, or what? Termination.
Now, my lord, it has been mentioned now, therefore, in exercise of power conferred 1014 of West Bengal.
Dismissed
Service
from
Rules-
service.
Yes, my lord. In order to penalty of dismissal
Culminated
of
into an
service.
order of dismissal from service. with effect from the date of impose of penalty. What is this English word?
Penalty of so
Full stop.
imposed upon
What is this? Upon means what? Impose of penalty.
page 44, not kindly see.
47, can you see? The last sentence?
Yes, my lord. Hereby dismissed from service with effect from the date of special secretary. What?
Imposition of penalty. The instant writ petition was filed, assailing an order of the tribunal dated 21/12/2022. Impliedly refusing to pass an interim order against the departmental proceeding initiated against the writ petitioner. Stop. After recording the submissions of the respective counsels, the tribunal surreptitiously arrived at the decision that the said matter should be heard by a bench comprising of 2 members, one judicial, another administrative, for better adjudication. And the liberty was granted to the writ petitioner to mention the matter when the said bench is available. At the time of admission of the instant writ petition, it was submitted on behalf of the writ petitioner that so far as the departmental proceeding is concerned, it is a subject matter to be decided. It is a subject matter of the tribunal application to be decided at the time of final hearing. But at least the petitioner should be allowed to resume the duty after he has withdrawn the resignation letter. Stop. Our attention was drawn on the last occasion to several memos, TWO, several memos issued by the government permitting the writ petitioner to resume the duty and subsequently withdrawing the same on the same day. However, an accommodation was sought accommodation was sought by the state respondent to take necessary instructions. And thereafter the matter has been listed. We'll stop. On the last occasion, when the matter came up before us, an oral submission was made on behalf of the state that the disciplinary proceeding has culminated into a final order of dismissal from service. And in view of such submissions having been made, we invited the state to put on records by way of an affidavit all the documents relating thereto. This aforesaid affidavit has been filed enclosing the document, including the order of dismissal passed in a disciplinary proceeding. Stop. The moment the order of dismissal has been passed, the interim protection in the form of resumption of duty becomes infructuous, as this court cannot direct the terminated employee to resume the duty. However, now since the purpose of granting interim order is frustrated by virtue of a subsequent order passed by the disciplinary authority terminating the service, there is no purpose of keeping the instant writ petition alive, which in our opinion has become infructuous. However, the liberty is granted to the petitioner to take an appropriate steps against a order passed by the disciplinary authority. Before the appropriate forum. Nothing observed herein above shall have any persuasive impact on any of the points available to the parties any first before the appropriate forum, which shall be decided independently.
Till I was not dismissed, I should be entitled to salary, my lord. That should be observed.
With effect from
that date of dismissal.
impose, I do not know what is the date
Date first
of
May
imposition
2021. First May.
Position of penalty, I don't know. I have not seen. Go.
No. But first May 2021 onwards, I have not received any salary. So I am entitled to that. Should be directed to
But
be
I
paid.
do not know because the retrospective effect has
No,
been given
the
by them.
order itself says with effect from.
With effect from
With effect from.
impose of penalty.
No, last page 46. Page 46, last paragraph. Kindly see.
47.
Page 47.
Yes, last paragraph.
With effect from 5th April 2023. Your lordship, kindly see. With effect from 5th April 2023. That is. Yeah, ठीक है. So
It has not been mentioned.
till
The exercise of power, that is the date on 5th of April.
No, that is the different. We did this department. that
Yes,
has been
department
pleased to
notification
order the
date is one.
service under such a
Then
post.
kindly see that at the top, 20th April 2023. The order
Understand, sir, that is what I find. There is some kind of a discrepancies or ambiguity in this regard.
Till I was in service, your lordship kindly observe, kindly direct, till I was in service, I should be paid my salary.
I understand you can go and renew that prayer before the authorities.
But,
But I do not know the effect from the date of impose of penalty. I do not
Nothing
know.
has been mentioned.
Nothing has been from which date the penalty is to be imposed.
But-
Any rule says that penalty should be imposed from a prospective date? I do not know.
And in paragraph 2 of that order,
No.
they hold, my lord, that he has been absented since 22/1/2021 without authority.
No, but your lordship kindly see, there is nothing
And
reflected in
instructed
the,
him.
there is
several
nothing
times, but he did
reflected in
not.
the
Sir,
final
that is
order.
why it's such a gray area and a complex one. They need to come and file their affidavits in this regard. You can go there before the tribunal and have it done.
Yes.
No, Lord, unless your lordship
Sorry.
kindly consider, Lord. Lord, I should be paid
Sorry.
my salaries
Sorry.
because till I
Ah.
was not dismissed.
After the order is dictated, the learned advocate appearing for the petitioner vehemently submitted that they should be paid salary for the period preceding the date of the order of termination. stop. We find that the order of termination would take effect from the date of the imposition of the penalty. And the records does not reveal such date from the such date when the penalty is imposed. So we do not intend to go into the aforesaid aspect. However, the liberty is granted to the petitioner to raise such issue before the appropriate forum. If raised, shall be decided on the basis of shall be decided after affording an opportunity of hearing to the contesting respondents in accordance with law.
I'm grateful.
আসছি রে বাবা। ডাকবো না?
Who is for the other side?
Yes, my lord, I'm appearing on behalf of the private respondents, my lord.
Who is for the state?
Well, everybody have been served.
Who is for the state? Who is for the state?
21. He is appearing on behalf.
Have you served in the GP office?
Yes.
21-3, long back. Where is Mr. Chandicharan or Mr. Basu Malik? You appear in the LRTT matter? Who appears? With? Tell your junior to call him. Can he come? Mr. Day, can your junior call him? Any other person who appears in LRTT matter for the state? No, he's not. He says that he has a contactless, I think contactless person because he does not use.
Mr. Lolit Mahato also. Okay.
Yes. What do you say? You are for Kolkata Municipal Corporation. What do you say? Who really contested it?
Lord, the
I
private
think the
respondents,
state contested it.
state and private respondents.
Petition has not been condoned, my lord. The fact is,
Sorry, you will come when I have section 5. You will remember all
no,
your.
I am not
arguments.
opposing, my lord.
So,
Your lordship directs the tribunal to expedite the matter.
absolutely,
Yes, my lord.
it has to be done because he has explained.
Yes, my lord. Another
It's
thing,
not
my
that
lord.
he has not explained at all.
Yes, my lord.
Section
I'm not
5.
opposing, my lord. The fact is this, that these Tika tenants are, or the
And
alleged Tika tenants
there
are
is a
suffering.
rudderless ship without destination. Radar, I can understand. Rudder,
Lord,
I
radar
do
is
not
there, destination is also there.
correct.
Lord, in fact,
The
there was no.
radar is not there, then definitely it's very difficult to find the destination.
Yes, yes,
But the destination is clear.
yes.
Your lordship,
Lord,
let it be decided within a specific time frame by the tribunal, my lord. That will suffice, my lord.
Section 4. Delay of 309 days.
Lord, there is no delay. I will have to explain. Lord, kindly see. Lord, on 12th April, the hearing was concluded regarding maintainability of fresh application under section 5.3 of the Tika Tenancy Act.
12th April.
12th April 2019.
12th April 2019.
And Lord, subsequently we came to
Hearing concluded.
hearing concluded. Lord, practice is there. Every date is communicated to the parties by notice. No date was communicated when the judgment will be passed. But subsequently, on the basis of a caveat lodged in the tribunal.
That I have gone through. You did not have to.
Yes. But then Lord, we got the certified copy applied on 28th November.
The order was passed on?
Order was passed on, that is on, Lord, I'm just telling.
September.
September.
Tell me which date?
September, 4th September.
4th September
2019.
2019. Order.
Yes, Lord, we applied for certified copy on
24th November or 28th November? When?
28th November.
28th November.
And got it on 9th January.
And you got it on 9th January 2020.
Yes, 2020. Lord, then Lord, we got a notice from the Thika controller that hearing has been fixed on 9th of January 17th December 2019. We got a notice from Thika controller that
when?
Lord, 17th December 2019.
Notice from
Thika controller that the self-same case is again fixed for hearing on 9th January of 2020.
Yes.
We appeared, but no hearing was taken place. And Lord, we got the certified copy of that 4th September 2019 on that day. Lord, thereafter, we waited. The next date was fixed on in the month of March 2030, in March 2020. On the basis of that notice. Lord, then we waited. Then what happened, we'll see. Then, Lord, there was pandemic. There was, Lord, everything was stalled. Thereafter, when it was relaxed, I requested that I do not know the fate of the matter. To file an application. Application was filed before.
Where? Thika controller.
Before the tribunal.
Application for what?
Appeal. This LRTT application.
When?
Lord, that is on the month. That is on. It was filed on. Sorry. Not just I'm telling. November 20. मैं लिखे दीजिए।
Should have come with a short list of dates
Lord, yes, Lord, yes.
indicating those dates.
কবে ফাইল করলাম যেদিনে ফাইল করছি
8/10/2020.
yes yes 2020 therefore Lord, according to me there was no delay at all.
Why you say no delay, sir?
Lord, in the application itself, supplementary application, I have stated that in fact there is no delay.
Why
I've
you say so?
Explained everything. Lord, kindly come to page 85 of the application.
What is the period of limitation? 1 year?
60 days. 60 days.
60 days from
The date
before
of
the tribunal.
order of the Tika control.
So the order was passed on 4/9/2019.
Yes.
Then you applied 28/11/2019, which is
Yes.
beyond 60 days.
Lord, because they didn't communicate.
Sir, that is a different.
Yes.
Mr. Ghosh,
Lord, I have
you
explained.
appear in a civil cases.
Yes, Lord.
You should know the law when the limitation starts.
Lord, that's why I started. That's explained.
Then that is a different issue. It is one thing to say no limitation applies, there is no delay,
Yes.
and it is another thing, there is a delay, but you have a sufficient
Yes.
ground to condone delay.
Yes, yes. That is so.
So say that, you say no delay at all. I have explained.
Lord, I have.
Don't say so.
Lord, I've explained. That's my case.
Say that it is a condonation.
Yes.
So 4/9/28/11. Take decision with the hungry stomach. Yeah. Even there is a proverb that even a prayer to a god cannot be made with a hungry stomach. So This date has come.
But the small issue involved in this matter is whether the proceeding initiated by the controller is maintainable. That was the sole issue. My lord, your lordship may take up this issue here, decide it.
Then what the tribunal will do?
Obviously, but
So can we bypass a forum?
no, my lord.
So that
Your
is what,
lordship fixes a particular time.
it's
frame,
a, it's
let
a
it-
jumping of the forum is not good.
Affidavits are complete, my lord, before the forum.
Affidavits
before the
are,
tribunal.
no.
Yes.
Affidavits are complete.
Yes, my lord.
Yes.
Section 5 stage.
Section 5, my lord, along with the main matter was heard in the month of August, in February 2020, month of August 2022, and in month of February 23.
Sufferer of the Thika tenants, my lord. The
They are not
fugitive-
Thika tenants.
No, I understand. That is what is there.
Yes,
They are
my lord,
not
but
Thika
the structure itself
Dago.
is dilapidated, my lord.
It it discerned in course of the hearing that pending an application under Section 5 of the Limitation Act for condonation of delay in filing the tribunal application, comma, the parties were directed to exchange affidavits in the main matter. Stop. By the impugned order, the court proceeded to hear out the application for condonation of delay and dismiss the same. As a resultant effect, there is no finding recorded on the merit of the said application, of the tribunal application. The tribunal has proceeded to reject the said application that the statements made in course of the hearing are not reliable and does not instill confidence in the judicial conscience that the writ petition was prevented by a sufficient cause. Full stop. The aforesaid observations appears to have been made for the simple reason that supplementary affidavits to be filed in course of the hearing, giving a giving a further explanations relation to a period which according to the writ petitioner was not sufficiently explained. Since the supplementary affidavits were filed, it gives an impression in the mind of the members of the tribunal that those facts have been subsequently introduced and to be treated as afterthoughts. Despite service, next paragraph, there is no representation on behalf of the state. Let the affidavit of service filed today be kept on record. The learned advocate appearing for the respondents, the other respondents, submits that the matter was in fact intended to be heard finally, as they disclose their stand on merit by filing the affidavits. Yet there is no decision taken by the tribunal in this regard. Let us consider whether the observation of the tribunal in relation to an application for condonation of delay can be sustained. Admittedly, the hearing of the tribunal application along with an application for condonation of delay was admittedly the Tika controller conclusively heard the matter on 12/4/2019, but did not indicate the date for passing the judgment. The judgment stroke order came to be passed on 4th September 2019. Which, according to the petitioner, was not within the knowledge. Furthermore, it is indicated that the learned advocate did not attend the office of the Tika controller due to his illness relatable to the old age, and finally, when he went to the office of the Tika controller on 28/11/2019, he came to know of the order being passed, and on the same day, the application for certified copy was filed. The certified copy was made available on 9/1/2020. However, in the meantime, if further notice was received by the writ petitioner on 17/12/2019 from the office of the Tika controller, that the next date is fixed on 9 January 2020. However, the instruction was given to take steps to challenge this said order. But the learned council was unable to do so till first week of March 2020 because of his illness and the reporting of the high number of cases due to COVID-19 virus. Ultimately, there was a lockdown declared in the country, and after the relaxation of the application was filed, It is no doubt true that during the lockdown, there was a complete disruption of an access which was gradually relaxed. And the functionings were of the tribunal or the courts was also very limited. Apart from the same, the court must encourage the litigation to be decided on merit instead of dismissing the same on the anvil of limitation. The decision, the adjudication on merit decision, the adjudication on merit would ultimately render the litigation to attain finality and will also inculcate a sense in the litigants that that the justice has been imparted. Stop. The court should not be swayed simplicity by the fact that the supplementary affidavits came to be filed disclosing the events which led such a delay to occur. As a ground for refusal to condone the delay. The court shall be guided by the sufficiency of the cause and should not adopt a pedantic and or technical approach in defeating the meritorious case. Full stop. We thus find that the explanation given in the application for condonation of delay is satisfactory, and the court ought to have taken a pragmatic approach to the issue. Stop. The order needs interference. The order warrants interference, and therefore is set aside. No, it is opposite to observe that the moment the tribunal decided that the parties should exchange their affidavits on the main matter, it ought not to be too technical on the application for condonation of delay, but should have decided the matter on merit. Tapor warrants interference, the same is hereby set aside, as a consequence whereof the application for condonation of delay is allowed, subject to the deposit of costs assessed at 3,400 rupees, 3,400 with the State Legal Services Authority within a week from date. Stop. Such amount shall be kept in an account earmarked for juvenile. Since the next paragraph, since the parties have exchanged the affidavits in the main matter, we presume that the same is otherwise ready for final disposal and therefore directs the tribunal to dispose of the same within 2 months from the date of the communication of this order, after affording opportunity of hearing to the respective parties.
But in the meantime, Lord, the Trigger controller has initiated another proceeding that may be stayed, my Lord. Otherwise, it depends upon the decision of this case. Kindly, similar another notice has been issued.
That's you go there. Liberty is granted, Lago. Liberty is granted to the petitioner to pray for any interim release if warrants so,
Yes.
and the tribunal shall decide the same. Keeping in mind time limit indicated herein above on its own, on its merit. All applications and or with the writ petitions. Let's call the next.
And I was appearing for the state fund in item 8. In item 8.
Why you did not appear? Sorry, this is a ওই জায়গাটা চেঞ্জ করে দাও যে despite service there is no appearance on behalf of the state, ওই লাইনটা কেটে দাও। Yes. 73.
Both are for the petitioners.
There are 4 writ applications.
Challenging the same judge.
There are 4 writ applications.
তখন ওরটা শুধু হবে যে পার্টলি অ্যালাউড রেস্ট কিভাবে আর সেই মুহূর্তে প্রসঙ্গে যদি একমত হয় তখন অন্য দিকে
Lordship will find the judgment at, in volume 3 at page 751. Sakyu Bisas. Sakyu
বলো
Volume 3, page 751.
Samin Hoshen.
Sakim.
Sahim.
Sahim.
Sahim Hoshen. তোমাদের নাম পড়া মুশকিল, স্যার।
May I take your lordships to the judgment?
that's the certified copy which
Right.
is annexed to us.
Yes.
Which is annexed to this petition.
Certified copy, I believe, starts from page 779.
No, it is a certified copy which is
It
given.
cannot be page marked, my lord.
It should not be anyhow.
Cannot
That's
be. Well, may I just start, my lord? May I give you lordship? My lordship kindly takes the first few paragraphs.
can you give us 4 or 5 minutes of time to go through the impugned order first?
Absolutely.
এই যে সামিম হোসেনটা কই? সামিম সামিম হোসেন। হ্যাঁ, সামিম হোসেন। 779 স্লিপারি উইকেট ভাই। Copy also.
The point, I believe, is very limited. We should not dilate on all the issues which have come.
Right.
The issue which appears is that a candidate who offered his candidature under a particular category and availed the benefit of age relaxation, whether such candidate, even on merit, can be placed into an open or an unreserved
Absolutely, my lord.
category.
That is the main
So
issue.
that's the main issue.
Right, man.
The tribunal has relied upon the various resolutions taken by,
Right.
the full committee or whatever.
Full commission.
Commission.
Yes.
Your stand, which is reflected in the reply.
Yes.
To me also, it appears to be somehow, I would say, like dilly-dally. Somewhere you said something, somewhere you said another thing. So there appears to be some kind of an ambiguity, which is apparent on the face of the record. There are two judgments. Jiten Singh's judgment and the other judgments have been distinguished by the tribunal on one score, because in those judgments it says that when there is no decision which has been taken by the recruitment committee or the rules does not provide, then the law as it stands is that this relaxation is only for the purpose of making them eligible to offer their candidatures. It has got nothing to do so far as the merit is concerned. So they are simply made eligible to offer their candidature. And if they excel well or they perform well and they got a higher marks, then the last candidate under the unreserved category, then they can be shifted. They can be shifted from a reserved category to unreserved category. The tribunal has distinguished that since you took a decision that you will not shift it, the one who have it, he has to be there. He cannot move out of its, the contour or the circumference. It has to be within that circumference. And therefore, that is an admitted position by you that some of the candidates have been wrongly adjusted somewhere here, some there, or something. You also admitted it.
Well, not wrongly adjusted. I did not.
No, you say that there is.
There has been
And then
adjustment.
the tribunal says that I am not going to scrap the entire selection process.
Right.
Selection process appears to me is good.
Right.
But I cannot approve the panel.
Right.
And then cause the panel.
Right.
And directed you to recast the panel on two grounds, which is already there. Ground number 1 and 2, the tribunal has indicated. They are aggrieved because they wanted the entire selection process to go
Scrapped.
in a river Ganges.
Right.
Which the tribunal has saved it, says no, there is a vessel which can sail on the river Ganges water. So there is no difficulty, sail it, but with this. Now you argue, because you will be arguing why the panel has to be set aside.
He will be arguing. My lord, I.
No. You will be arguing
Right.
that there was no occasion to set aside the panel.
Right. Yes.
That you will argue
Yes,
as a
I will
commission.
argue. I will argue.
They will argue that what was the necessity? What was the occasion not to scrap the entire selection process? They will argue this point.
Right.
So let us consider.
Absolutely.
If you succeed, then the panel which was prepared has to stand.
Right.
Correct.
Right.
Subject to his stand being taken there,
Right.
whether the entire selection process has to go.
Absolutely. Absolutely.
Because if he succeeds, the entire selection process goes, then the panel is I would say the outcome of or fallout of the selection process. So that will automatically go. It has to go. So please address me on that issue.
Yes.
No other issues.
My lord, may I just take your lordship first to some of the portion of the judgment, my lord, which I believe, my lordship has gone through, but only those paragraphs.
Yes, you can. That's why we said, let us go through the judgment.
Yes, my lord,
in
kindly
its
take, my lord,
entirety.
I start from paragraph 24 straight away.
Yes.
23, the tribunal holds that the question of quashing the entire selection process as prayed for does not arise as the appellants had participated in the process without any protest at any stage whatsoever. An important issue, paragraph 24, whether selection and recommendation of the candidates belonging to the reserved categories, scheduled caste, scheduled tribe, other backward classes A and B against unreserved vacancies, in spite of availing of age relaxation is permissible or not in the light of the provisions contained in the West Bengal Scheduled Caste and Scheduled Tribes Reservation of Vacancies and Services and Post Act 1976 have been raised in this regard. It is appropriate to refer to section 4.2 of the 1976 Act. Since subsection 2 of section 4 is quoted, the member of any scheduled caste or scheduled tribe candidate qualifying on merit for appointment to any unreserved vacancy in a service or post in any establishment to be filled by direct recruitment shall not be deducted from the quota reserved in such service or post for such candidate under subsection 1. Then, my lord, section 5A and 5B of backward classes other than scheduled caste and scheduled tribes, reservation of vacancies in Service and Post Act 2012 says as follows. Subject to other provisions of this Act, 10% of vacancies shall be reserved for candidates belonging to other backward classes, denoted as other backward classes category A, and 7% of vacancies shall be reserved for candidates belonging to other backward classes B category of other backward
17%.
Yes, 17%. My lord, the members of the other backward classes qualifying in merit in an open competition on the same standard as of unreserved category candidates for appointment to any unreserved post in a service or post in an establishment to be filled up by direct recruitment shall not be adjusted against the quota reserved in such service or post for such candidate under subsection A. My lord, I would be making submissions on these two provisions later on, my lord. May I just take your lordship to the provisions first? While dealing with the issue, it is appropriate to refer to the eligibility criteria set out in the advertisement, which is as follows: age not below 18 years, but not more than 40 years as on 1/1/2018. So concession in age. The upper age limit is relaxable by 5 years for SC and ST and by 3 years for backward classes, non-criminal candidates. No relaxation is applicable to SC, ST, BC candidates of other states as they shall be entitled as general unreserved candidates.
Obviously, because somebody may be under the backward classes in other states
may not
have
be
a diversity.
Yes. Because for every state there are different kinds of
Demography of our country is such that we have a diversity.
The identification will vary
every
from
100 to 100 kilometers.
Absolutely, the identification will vary from state to state. Now kindly come to paragraph 27. Perusing the statutory provisions stated herein before, it is evident that the members of backward classes qualifying on merit
that we have gone through it, because so far as the OBC is concerned, same standard means the court has held, or even a tribunal has held, same standard means that they are kept at par, and in that event, so far as those candidates are concerned, switching over is not impermissible.
Absolutely, my lord. Absolutely, my lord.
For OBC A and OBC B.
Absolutely, my lord. My submission would be.
What about the scheduled caste, scheduled tribe?
My lord, I tell your lordship. My lord, may I just state the admitted facts? The facts which are beyond dispute. Fact A, some candidates belonging to scheduled caste, scheduled tribe, or OBC A and B were given age relaxation, or they availed of age relaxation. Fact. Different cutoff marks were found for different category, or ascertained or fixed for different category of candidates.
Most logical,
unreserved, SC,
scheduled caste,
ST,
SC, ST, OBC A, OBC B. No difficult.
My lord, our is that age relaxation
is only a measure to create a level playing field for these kind of candidates, this class of candidates, namely SC, ST, OBC. It does not create a relaxation of standard on merit.
That is what I indicated
Yes,
at the first outset.
That is why
I said so that this is what it appears,
yes.
but your stand in a different supplementary affidavits.
No, my lord. Perhaps, my
Uh,
lord, the supplement.
think
Well, I will read all the paragraphs. I will read the necessary
that
paragraphs.
is quoted here.
I will read the necessary paragraphs. Once I read the all the relevant paragraphs, your lordship will find that there is no incongruity in stand taken by PSC. If your lordship kindly takes the resolution, kindly take the resolution for once, because that resolution has been cited and relied on.
I am inviting your attention
Yes,
to some of the observations which, according to me,
absolutely, my lord. Certainly, my lord. It's my duty
after
to answer.
this, the judgment of Jitendra Singh, then Nirav Kumar. These two judgments, I think, were placed. Then
The tribunal followed Nirav Kumar.
Then.
Yes, I'm sorry.
Then you'll have to consider it. Yes, you can start from
Yes, my lord.
paragraph 40, I
40.
believe.
Very well.
I think the real reasons came out.
Yes. Paragraph 5R of the original application.
That is their statement.
That is their statement.
Yes.
There has been a clear violation of the reservation policy in as much as candidate applied for OBC category has been selected in unreserved category without disclosing the particulars and details in regard to the merit of the candidate. This act also points out to the lack of maintenance of transparency or in the process of public recruitment.
Yes.
In paragraph 5F, it has been alleged that the merit list was published in violation of the reservation policy as guaranteed under Article 16(4) of the Constitution of India. And some examples have been given regarding the grant of marks to the last impaneled candidate in the general category. And it has been stated that in the instant merit list, Public Service Commission West Bengal has not prepared the merit list in terms of the merit of the candidates in different category, having result to that the candidates who got highest marks from different reserve category could not be placed in the unreserved category due to the inaction on the part of the Public Service Commission West Bengal.
Yes.
Paragraph 5G, it has been stated that some violation is cropped up in the category of scheduled caste where there is a candidate, roll number so and so, got 97.004 marks into as total marks. Total marks.
Written an interview, they have indicated, written an interview,
which is more higher than the last impaneled candidate under the general category in the instant case. The candidate being roll number so and so under SC category is entitled to get a chance to compete the selection process with the advantage of unreserved category candidate. These paragraph statements have been countered in paragraph 17 of the reply filed by Public Service Commission, which is as follows. Allegations contained in paragraph 5R of the application are baseless, frivolous. I deny and dispute the same and state that the Commission did not violate the reservation policy. According to the policy, candidates having any category other than general category can also be considered in the UR category list according to their merit. Further,
accepted it. You accepted his contention.
Yes. Yes.
Then?
Yes, absolutely. I stand by that. Further, in paragraph 27 of the reply, while the Commission disputed the statements in paragraph 5F and 5G of the original application, the relevant portion of which is as under. According to the verdict of Hon'ble Supreme Court in a case between Nirav Bhai Kumar Dilip Bhai by the government of Gujarat, in case members of SC, ST, OBC can compete against non-reserved categories can be counted against them in case they have not taken any concession like that of age, payment of examination fee in case of direct recruitment is justified. For that reason, above, due to the decision of the full commission meeting dated 21/8/2018 and its extended meeting held on 30/8/2018, mentioning 7B. Well, this is the resolution, my lord, which basically is the linchpin in this entire matter. 7B, preparation of merit list for relaxed standard. It has been further decided by the commission that the candidates who will avail relaxed standard of any reserve list at reserve category at any stage, that is written examination or interview, etc., will be considered only for merit list for that
So
particular.
you restrict them. Suppose if he has excelled well in a SC or ST or OBC category, irrespective of whether he has obtained more marks, he has to be kept in
But
that
I tell
category
you,
itself.
Lordship, apropos what has fallen, this is perhaps the most pertinent question right now. May I answer your Lordship's pertinent question right now before I take your Lordship to the other aspects of the matter?
So this
Mala,
was
take
your
a case.
stand.
Mala, take a
This was
case.
your stand that I will stick to it.
Yes, I will stick to it. Mala, kindly take.
Then the next page is very important.
Here in this case, the candidates in question failed to secure the cutoff marks obtained by the last qualified candidate in the written test for UR category, but achieved sufficient marks in the respective category in order to appear in interview. Since they avail the benefits of reservation at the time of appearing in at the personality test, their names cannot be considered against UR vacancies. I state further that I repeat and reiterate paragraph.
Correct.
My lord, may I just answer to your lordship? My lord, I will take your lordship to these paragraphs. These paragraphs have not been set out in full. They should have been set out in full. My lord, whatever it may be. My lord, I tell your lordship, my lord, kindly take a case of an SC candidate. My lord, for illustration. An SC candidate secures 50 marks in written interview, written test. And my lord, say for example, 20 marks in the personality test. That is the interview.
What?
50 marks in written test, 20 marks in the personality test. The last marks obtained, the marks obtained by the last empaneled candidate under the UR category in written test is, say, my lord, 55. The marks obtained by the last empaneled candidate under the UR category, well, let's say for example, is 55, which is higher than 50. Now, my lord, one candidate under the UR category, he secures, say, my lord, 13 marks in interview or personality test. The total goes to 68, 55 plus 13, 68. Whereas the candidate who is under this SC, ST or any other reserve category secures 70% marks in aggregate. One is 68% marks in aggregate, and the 70% for 70 in aggregate. The question will arise is that you were given a relaxed standard of evaluation at the stage of written test so that you can participate in the personality test. Once you have been given that relaxed standard of evaluation and you were given an opportunity to participate in the personality test under the SC/ST category, you have to be adjusted against SC/ST category alone. Malad, take a converse case. Malad, a reserve category candidate, say for example, secures Malad 55 marks in Malad this written test, and my lord also secures my lord 15 marks in the interview. It may so happen that the marks obtained by the last empaneled candidate under the UR category, so far as written test is concerned, is 55. Whereas if we add up the marks of that last empaneled candidate or any other candidate, the last empaneled candidate, as per the aggregate, would be, my lord, under general category is 68. So, my lord, this candidate who has already secured, who has not availed of the benefit of any relaxed standard or norms, would have to be accommodated against the UR category, because the whole objective, my lord, I will citing authorities one after another. My lord, this Nirav Kumar, which forms the, my lord, the sheet anchor of the submissions made on behalf of the petitioners in this case, is a standalone case. Why is it a standalone case? I put the question to myself with all humility, because in that case, the government of Gujarat issued one by one 2 instructions indicating or clarifications indicating that yes, age relaxation in case of our appointment to be recruitment to be given would be considered as a relaxation of standard. And that kind of instruction or circular or, my lord, this clarification is not available in the facts and circumstances of our case. Our case is more akin to Jitendra Singh, but I would not be relying solely on Jitendra Singh. I will start with N.M. Thomas. I will take your lordship to the relevant paragraphs of Indra Sahni. I will take your lordship to the 83rd Amendment Act, Constitution Amendment Act, and also 88 Constitution Amendment Bill. Then I will take your lordship to, my lord, this recent judgment rendered by the Honorable Supreme Court in Neil Aurelio Nunes, that is sometime in 2022, and 2 other judgments. But I tell your lordship, the whole idea is that it may be atypical in the case of, in the state of Gujarat, that age relaxation is considered as a relaxation for the purpose of deciding whether a candidate could be accommodated against reserve category or general category. But this atypical case, which is tailor-made bespoke for Gujarat, cannot be made applicable perforce in other states, namely in West Bengal. Well, that would be my submission before your lordship. Well, I take your lordship to the paragraphs. Your lordship has read the judgment. I don't want to waste your lordship's time, because I know your lordship doesn't want time to be wasted. Well, kindly take the paragraphs in the way, and the reply. Straight away. Kindly take the paragraphs one by one. No, acting. Now, barcode to the. Yes. First paragraph. No, এটা না, আমার first volume দাও, first volume, first volume দাও।
Page 84.
Well, kindly take, my lord, the volume 1, my lord, for your lordship's consideration. Because, my, so far as I am concerned, I know that time is of essence in this court. I will not waste your lordship's time in just dabbling about. Well, kindly take paragraph 5R. Your lordship has seen paragraph 5R at page 81 of the application, of the original application. My lord, kindly take, my lord. There has been a clear violation of the reservation policy in as much as the candidate applied for OBC-B has been selected for unreserved category without disclosing the particulars and details. In regard to the merit of the candidates, the Act also points out to the lack of maintenance of transparency in the process of public recruitment. Then, my lord, kindly come directly to paragraph 5FF. This is extremely relevant. At page 84, the 5FF 5GB reply gulo bar bolo. Na, ami jani. May I take your lordship to 5FF? The applicant state that the Public Service Commission West Bengal published a merit list of candidates qualified for recommendation to the post of sub-inspector in the West Bengal Subordinate Food and Supply Service Grade 3 under the Food and Supplies Department, Government of West Bengal, in violation of the reservation policy as guaranteed under Article 16(4) of the Constitution. In the merit list for the post of sub-inspector in the West Bengal Subordinate Food and Supplies the last candidate under general category who obtained recommendation for recruitment got 91.1671 marks out of total 121. So the perception on the basis of which this original application was moved was aggregate. Then the candidate under OBCA category got highest 97.005 in terms of general rule of selection in compliance with the statutory provisions of the reservation policy. It can be easily presumed that the candidate being roll number 212831312 under OBCA category who got 97.005 marks is higher than the marks obtained by the last impaneled candidate under general category. He or she can be featured in the category of unreserved category in terms of merits. In the instant merit list, the Public Service Commission West Bengal has not prepared the merit list in terms of merit of the candidates under different category, having resulting to that the candidates who got highest marks from different reserved category could not place in the unreserved category due to the inaction on the part of the Public Service Commission West Bengal. So, my lord, pausing here for a moment. It is also the case of the petitioners. Yes, adjustment is possible. The law permits adjustment. The same violation cropped up in the category of scheduled caste where a candidate being roll number 0320484 got 97.0004 marks as total marks, again aggregate. So emphasis always supplied to aggregate marks. Written plus interview, which is more higher than the last impaneled candidate under general category. In the instant case, the candidate being roll number 0320484 under SC category is entitled to get a chance to complete the selection process with advantage of unreserved category. Then, my lord, kindly take the reply.
Page.
My lord, the reply is starts at এটা কোনটা দিচ্ছ? Yes. Yes. আমি মেন রিপ্লাইয়ের কথা বলছি। আমাদের সাপ্লিমেন্টারি এফিডেভিট। হ্যাঁ? দাও রিপ্লাই দাও। মানে kindly take our reply which starts at 60, it is original application 607. এটা হচ্ছে 607 হচ্ছে ভলিউম 3
relevant para page 613.
হ্যাঁ মানে kindly come directly এটা আমার ফ্ল্যাগ করা আছে why I tell your lordship the entire affidavit has not been set out would be evident from paragraph 27 of my reply at page 613.
It starts with 607.
Absolutely, my lord. Well, I am extreme. Well, I'm so sorry, my lord. I should have pointed out the first page of the affidavit.
And then you are referring to 613,
my lord. Paragraph 27.
Paragraph 27.
Where I deal, first, my lord, I deny paragraph 5R at page 610. That's a denial.
Paragraph 16.
17, my lord. 17.
Yes.
Then, my lord, kindly come to paragraph 27. This table.
Yes.
The allegations contained in paragraph 5FF and the 5GG of the said application. I deny and dispute each and every allegation. I state that the applicants are trying to establish a false allegation on the basis of aggregate marks obtained by recommended candidates being roll number 2128312 and 0320484 who were recommended in OBC A and SC category after getting 97.005 and 97.004 marks respectively in aggregate. Whereas the last recommended candidate under UR category got 91.1671 marks. The applicants may get the answer on going to the information furnished below. This is not discussed even.
What are the information?
Kindly take the information. Kindly take one case each. 2128312. Munna Aziz, OBCA. My lord has got that.
Yes.
My lord, written he got 79.005. For UR, the cutoff marks for written was 79.6671. 79 points. So, my lord, it is the marks obtained by this candidate, namely Munna Aziz, in written test was lower than the cutoff marks for your candidate. So, my lord, if he had exceeded.
The question is when a panel is prepared,
Yes.
it is prepared on the basis of a total marks which you obtained in all tier of the examinations, or it is segregated into several categories of the parts.
Yes.
That is in relation to this, the written test, then the interview, I do not know the credential about the qualifications.
Again, a question of extreme importance. Again, a relevant question of extreme importance. Why? In case of these kind of tests, these interviews which has two components.
No, the tribunal has given a rationale in this regard. The tribunal found that because of the enormity of the candidatures who are offering their candidatures, in this case probably above 11 lakhs applications were there. Out of that, 7 lakhs and odd, 7 lakhs and odd, they appeared in the written test. Now, are you preparing a panel at the different stages of the examination, or it is a one final composite panel which you prepare?
One common composite panel, but subject to your lordship.
So will you make a distinction in a written test as well as in a personality or the interview?
Why? Because
can you make it?
Well, I tell you, lordship, I give you.
Or it is on the aggregate.
I tell you, lordship, give your lordship immediately the answer. So far as interview is concerned, the full commission there is a decision of the full commission which is followed, and that is beyond any dispute. That for interview there is no cutoff marks. It may be somebody may get 5 in interview.
No, cannot be.
Right. Interview there cannot.
In that.
Yes. But now your lordship will kindly compare, kindly take the relevant resolution, that is resolution, the item number 7B, that if at any stage relaxation on merit, I'm on merit right now, because today the entire the judgment is based on a perception that age, relaxation of age on a concession in terms of age, or increasing the age limit for a particular class of candidates would itself amount to relaxation for the purpose of adjustment of reserve category against general category seats. That is not so. My resolution is very clear. My affidavit is also very clear. My affidavit should have been considered in totality. This particular table was not considered in totality.
Let us consider.
Yes.
We are considering.
Yes, your lordship, certainly, my lord.
Now the question is, when you prepare a panel,
right,
do you not consider the total marks
I have
the
to, my
candidate obtained, and then you will have to apply that particular standard that a candidate who offered his candidature under the reserve category, if he gets the total aggregate marks which is higher than the last candidate under the unreserved category, then in that event, why you will make a further sub-classifications that this shifting would depend upon the marks obtained in the written examination only, and not on the basis of a written examination plus interview.
Well, I answered to that, my lord. My lord, in an examination, well, I tell you, lordship, in this case, the 11,06,359.
7 lakhs are not they
7 lakhs are
actually
not
appeared in.
here. Total vacancy was 957. UR was 454. OBCA 98, OBCB 69, SC 208, ST 558. Then MSP, that is a case of, my lord, horizontal. My lord, I am not on that. My lord, then we leave it to that. My lord, kindly take a case, my lord, has fallen from my lord. I must answer to your lordship's query. Suppose we go by the method of aggregate. and prepare a composite panel and without taking into account whatever marks or creating a sub-classification or creating an anterior and posterior stage. Well, we are at 2 stages. Well, whether that creation of stages is artificial or not, I think that is the question which is troubling your lordship, subject to your lordship.
Definitely, because I'm just trying
I
to
understand.
find
Well,
out the intelligible
differentiate. It's a
differentiate
question
in
of,
that regard,
it's a
that there
question
must
of
be a
when we
rationality.
talk about 14, any classification has to be based on intelligible differentia so as to meet the touchstone of Article 14 and
Absolutely,
16.
Absolutely.
My lord, when we approach the matter, taking into account the aggregate marks, kindly take, my lord, a case where the highest marks obtained, forget about the classes. We have to forget about the classes at that stage, my lord.
Correct.
If we forget about the classes,
Correct.
we find, my lord, the candidates, the nature of candidates, once it is treated to be homogeneous, we find there will be one list subject to lordship's kind consideration. Then, my lord, the highest marks or the marks obtained by the last empanel candidate would also cover UR, OBC, my lord, OBCA, OBCB, ST, and SC. In that event, my lord, the entire process of maintaining reservation would fail.
How?
Well, I tell you, lordship, why?
No,
How?
let us
Yes.
understand the example. I may be wrong, please.
No, my lord, my lord,
Subject
it is my
subject to
duty.
corrections
It is
and
my
subject
duty
to
to
what you
assist your
clarify.
lordship, my lord.
In a competitive examinations or in a recruitment process.
Right.
So you have to, first step is to ascertain the total number of vacancies for which you will conduct the recruitment examinations, recruitment process.
Right.
The moment you ascertain the total number, then you'll have to ascertain the numbers under the particular reserve category as
Correct,
per
my
the
lord.
law.
Correct.
Then you segregate those.
Right.
And then you come to a particular, the stage that this is the unreserved, total numbers is unreserved, this is under SC, ST, this is under OBCA, OBCB, whatever.
Right.
You come to this. And the recruitment process, when you start, it is the same standard which you really undertook,
Right.
because all these candidates
Yes.
have to complete the same question paper which has been given to irrespective
Your
of the
lordship-
categories or
your
the
lordship
class.
is absolutely, my lord, my
Correct.
lord.
So what you do is the same standard.
Yes, my lord.
Now question is, the one has done well, one has done
No, not so well. Not
just
so well.
below well,
Yes,
some
not
has
so well.
done average, some
Some
is
are
very poor,
very poor.
like this.
Yes.
Now, the moment you get the marks in the written examinations,
Right.
definitely, since the number of vacancies is very low, in commensurate with the number of the candidates who offered their candidatures, then you will definitely find how many candidates have to be called for interview. Here you have called everybody.
No.
You have to find.
Fine.
There must be a rationale in it.
Yes.
Then how the rationale is to be considered.
My lord, I answered to your lordship, my lord.
Now,
The last question
I'm
which fell
again-
from my lord was very.
I'm coming.
Yes, ma'am.
I know what you want to say. Don't derive. This is not a final one.
No.
So you can make a distinction on that basis,
Right.
just to curtail the number of the candidates. It may be 1:3, it may be 1:2, it may be 1:5, it may be 1:10. You can call. So in a category wise, when you do it, then you'll have to do it in a uniform manner, that whoever got the marks, you have to go by this standard. Somebody, suppose a written test is of 100 marks. Then who has got 97, 98, you have to come down. And then that ratio, if you want to maintain, then you will have to maintain a ratio. The total numbers you got. It so happened there that the number of the unreserved categories have excelled well, and they are above.
Right.
They are exceeding 1:10, say the ratio.
Right. Absolutely, my lord.
Correct.
Right.
Then you'll have to then segregate the scheduled caste and the scheduled caste, where you find under the unreserved category, the 1:10 where it ends.
I tell you, lordship, my lord,
Then you'll have to find out under the reserved categories how they can be adjusted.
Whereas, my lord, subject to lordship's kind consideration, subject obviously to correction, my lord. It's always subject to correction, my lord. When a candidate,
Just one.
I'm sorry. আর আছে এরকম আছে? সেটাই তো কোনো ক্লাসিফিকেশন ছিল। ঠিক ঠিক ঠিক। আচ্ছা এটা কোনটা? সেটা কি 3000 ক্যান্ডিডেটের লিস্ট? জিজ্ঞেস করুন, জিজ্ঞেস করুন। হ্যাঁ হ্যাঁ হ্যাঁ। কোথায়? সেটা তো 900 কত? 3000 3000
তার মধ্যে কিন্তু সেকেন্ড কাস্ট হতো না ক্যাটাগরি ফার্স্টে দেখি category
কোনখানে? হ্যাঁ ধরবে নট টুডে করিয়ে দে, আমি তো যেতে পারবো না। কৌশল চলে যা, কৌশলকে নিয়ে যা।
তোমার সেটা এটা হলো here are second situation. This appears to be more less than situation. Here are the both the check correct sense because we want to jump it to the then particular category to that.
দেবে তো বটেই, এটা তো অসুবিধা কি আছে, তো পাবলিক ডকুমেন্টস। কটা কপি আছে? দুটো কপি আছে? আরে এই যে 907 এটা জাস্টিস বিন্দালের একটা কপি রাখতে হবে না? কপি রাখবে না এরা? Yes, ma'am. And if your lordship, may I take your lordship back to page 613, and then I will take your lordship to the chart. The list actually. Lordship will find for marks for this Abdul Aziz, sorry, Munna Aziz, the written he obtained 79.005 in my lord this written, and interview he obtained 18 marks. In total, it was 97.005 marks. Whereas cutoff marks obtained by last qualified candidate of each category in written test for UR, it was 79.6671. For SC, it was 76.0006. For ST, it was 59.3339. For OBCA, it was 74.6673. And for yes, 7103. And OBCB, it was 75.33339. And another candidate, the other instance given by the petitioners in the way is OB1 Obijit Shodhar, belonging to SC. He got 79.004 in written, which is below
For the SC.
SC, which is below my lord the UR, the cutoff marks for UR.
No, no.
Yes. My lord 79.6
004 and
79.667.
Yes.
My lord, what I have done, my lord, etai dao ar ki kora jabe. My lord, this is the list. My lord, my learned friend, I think this is the list which was published on the basis of an order, in view of an order passed by this honorable court in the earlier round of litigation. Your lordship will find, my lord, each and every candidate belonging to different categories has been dealt with, and your lordship will find somewhere even general candidates or the UR candidates have got less marks.
So what I find, what this chart shows.
This chart shows, my lord.
I'm telling you what I gather. Please correct me.
No, my lord, kindly.
What I gather was
Yes.
that while preparing a list
Yes.
of the candidates in a respective category eligible for an interview or the personality test, you have segregated the candidates. You have put the unreserved category candidates at one site, and then you determined according to the ratio, whatever, 1:2, 3, 4, 5, 10, whatever, you have done them. And then you have taken out the SC candidates, 1:10 ratio according to this, then ST like this. It appears to me that you say, but I believe that is not a perfect way of doing that.
My lord, that has not been done, my lord.
That is not what
your lordship is absolutely right. That has not been done.
It should not have been done.
It could not be done.
That's absolutely, I say, my mind is open.
Yes, my lord.
It is only after reading this,
No, my lord.
something comes in my mind, so I am reflecting.
Your lordship need not say that. We always know, my lord.
Suppose what I feel is that suppose if there is let us proceed on that basis that there is 1,000 vacancies.
Right.
Hypothetical case.
Right, absolutely. More akin to this case.
1,000 vacancies.
Right.
Advertisement is invited, 11 lakhs application, 9 lakhs or 8 lakhs candidate sat in the examination, written test, and the written test is conducted on a same standard, same standard.
Right.
Now, if 1:10 ratio is adopted for calling the interview, then for 1,000 posts, 10,000 candidates have to be called. 1:10 straight away.
Yes, yes, yes.
Then what is required is that you have to find out from the merit, from the top, that this is the candidate, and then you stop at 10,000. Now, question is,
Right.
it so happened that there are less number of reserve category candidate in that 10,000.
Right.
And there is a large number of
General
unreserved category which exceeds 1:10 ratio.
Right.
I'm quite
Right.
conscious.
Right.
It exceeds 1:10 ratio. This is not permissible.
Right.
It cannot.
Mm.
Then you will have to filter out. You have to go up.
Right.
Means from first is from ascending to a descending order, and then from reverse the descending to an ascending order. And then stop at a situation where they say 500 is the total post for unreserved. So 5,000 candidates where you find, you have to stop there. So far as unreserved category candidates is concerned, even that may include certain reserved category candidates because they are more
Meritorious.
meritorious. So you have to filter out to maintain 1:10 ratio so far as unreserved. Similarly, the one who have been left out is gone forever, unreserved. So far as the reserve category, suppose the SC is 100, you have to call 1,000. Then some of them has already gone in the unreserved.
Unreserved.
Somebody may still be there, then you will have to categorize them from SC 100 because you can't take SC, ST together. You have to. Then SC 1,000. If ST is 100, then 1,000. If OBCA is 100, 1,000, or like this, you'll have to categorize.
Right, right, right.
Now the second situation may come. Suppose after the interview, the total aggregate marks somebody obtained. Then in that event, suppose the candidate who has been filtered and have been taken out from an unreserved to a SC category, irrespective of what the personality test or the interview marks he obtained, he has to compete within that SC. It so happened sometimes that the SC candidate who is there in unreserved category, because having obtained so higher marks, he could not find place within that 500 bracket. 1:10 ratio.
Right,
Yes,
right.
because of the personality. Then he must get a chance for that respective category where he is. If he get the chance within that 100 under the SC, he will get it. That's the double benefit he gets.
Right.
If you adopt this, then this has to be adopted. Otherwise, the second course is that on an aggregate basis,
appear in the written test a list which is not a what should I say, a list without classification is published on the basis of the marks obtained by the candidates.
no, that should be.
That is done.
No difficulty.
But then what happens? When in case of interview, so far as West Bengal is concerned, Public Service Commission of West Bengal is concerned, no cutoff marks is assigned to interview. There is no cutoff. That if you even if score 0, that will be considered in a different perspective. 2, 3, 4, 5. He will find from the list somebody.
That means that's why I asked.
Yes.
If you do not maintain a ratio
Yes.
Then whoever has competed in the written examination is called for the interview.
On the basis of marks. On the basis of the marks. The first
Uh,
3,000 were called for interview. The first 3,000 were called for interview.
I do not know. Then under what basis you do it?
Malad, I tell you, Lordship, Malad, this
Under what basis you
statistics
do
we
it?
have got, number of candidates called for personality test was 3,024. Subject to correction by Mr. Sannal, I may be incorrect.
Then
because
it is really 1:3 ratio.
Yes, more or less. Yes, more or less. Because
1:3 or 4.
957 is the total number of vacancies. Then, my lord, it has subcategories, namely UR, OBCA, OBC.
No, these are total number of vacancies is 900 and something. Then we'll have to find out
It
this
is 1 is
ratio.
to- It is basically 1:3. 1:3, keeping in view the roster point and everything.
How many? 3,000 candidates you call?
3,024 candidates were called
Correct.
for
So
personality.
practically 1:3.
1:3, my lord.
Practically.
Malad,
If you want, then you will have to follow a particular principle.
The principle which was followed at the time of publishing.
Is there any rule which is there in
Malad,
place, or
Malad,
it
there
is the decision of the committee?
Malad, I have to check up, Malad. That I do not know. Malad, I will not submit without instruction. But Malad, what has been done, and done in all cases, I tell you, Lordship, accent, boso, Tanda matay shono age. 3,024 candidates were called for personality test on the basis of marks obtained by them.
Irrespective of their category.
Malad, forget about it. It's a classless list.
Correct.
It's a classless list.
More, I would say more an omnibus or a
Omnibus, my lord, it's a compendium mode.
Correct.
Let us take my lord, Lordship's favorite word is compendium generally.
Yeah.
So more compendium mode. If it is a list in compendium mode, then my lord, they appear for interview or personality test. They obtain ABCD marks in interview. My lord, when they obtain ABCD marks for interview, on the basis of the marks obtained in, my lord, this written test and personality test, final list has to be published. Then, my lord, an exercise is carried out. What would be, then my lord, the vacancy position is examined. An exercise is carried out. What is the marks obtained in written test by the last impaneled? Who would be the last impaneled candidate under any of the categories? They identify 90 for example, 80 for UR, 70 for SC, 75 for ST, but it may so happen. 76 for, my lord, OBCA, 72 for OBCB, and so on and so forth. When this relaxation, my lord, relaxation would be in comparison to the marks obtained by the last impaneled candidate under the UR category, then this is a relaxation of standard or lowering of qualifying marks for these kind of candidates. Lowering or whatever it may be, but it's a relaxation of the evaluation standard. Somebody is getting less marks, obviously is less meritorious. But let us be very clear. So far as that examination is concerned, well, though personally I don't believe in this entire process altogether. Because I was never a good examining. Well, then what happens, my lord? Suppose this candidate under the SC category gets 80 marks in the written test, whereas the cutoff marks for the general category comes to 79 marks so far as written test is concerned. Then this candidate can no longer be considered as a candidate whose selection could be made against the reserve category. This candidate has to be selected.
Then what are you doing, sir?
Yes.
Suppose he is considered under the unreserved category. Now his performance in the interview may not be that.
Yes, my lord. Then what happens, my lord? Suppose, my lord, the total marks he gets, your lordship will find from the list. There are several instances in the list, not one. And I can show from the list.
No, I was just stating from your example. Suppose a person who is under the reserve category got 80 marks in the written test.
Correct.
And the last candidate, according to you, under the unreserved category is 79.
Right.
So you have shifted into an unreserved category.
Provided he also secures the requisite cutoff marks in total.
The difficulty is this, because then
And my lord, your lordship will find from the list, there is no incongruity. The list is clear. Nobody has challenged the list.
then according to you, you have taken taken in mind the interest of the unreserved category not to be overreached by a candidate of a reserved category.
My lord, it is striking a balance, my lord, subject to correction by your lordships. It is like striking a balance. Why striking a balance, my lord? The entire dispute is not with regard to the marks which have been obtained by the candidate. The entire dispute which has been raised by my learned friends, clients, my lord, the petitioners, I mean the original applicants.
Their case is very categorical.
Their case is
Their
very
case
that
is
once
the written and the personality test or interview
yes
have to be clubbed together in order to ascertain whether a particular candidate should be kept under the unreserved category or a reserved category. According to him, certain meritorious candidates under the reserved category, they obtained higher marks than the last cutoff marks in the unreserved category. They should have been placed there.
Yes.
Having not placed and kept in the reserve category, they say that zone of consideration becomes a bit
understood, Malad, understood. But
smaller.
essentially their case before the tribunal as well as in the earlier round of litigation before this honorable court at an interlocutory stage was that once somebody
but the pleading says so.
Yes.
5R.
Your lordship will find.
FF.
Your lordship will find in the supplementary affidavit. In a
they have taken a reverse situation.
I will place that. I will place that. Malad, I understand, my lord. I will face objections, but I will place that. But the main case, subject to correction by Mr.
Again, I requested all of you, because these are all motion days and these matters will take time.
This matter will take.
It's better to have a Saturday invested for that.
My lord,
I always insist.
my lord, that reservation we are not agreeing, my lord.
But there was one court on the Saturday on where the members of the bar accepted it. Gladly,
forget about this Saturday is a long weekend. This Saturday is a long weekend.
Last Saturday, I also requested Mr. Sanyal that you please come on Saturday and do it.
Malad, this is where Malad, this is.
So what is the difficulty? The members, they appeared on the last Saturday. There was one bench which was constituted, and the chief was very happy and permitted that court to hold.
That was one AP, my lord.
This is also one case. You need not have to rush to other courts where your matters are being called.
Section 9, maybe something would have happened on Sunday, my lord. We don't know, my lord. That's when the AP section.
It was a hearing matter.
Oh, it was a hearing. That I do not know, my lord. That I will never make that submission. I was not aware.
It was a hearing.
Before my lord, Mr. Justice Bhattacharya.
Yes, it was a hearing matter which continued till recess.
My lord, what should we do, my lord? Kindly suggest us, my lord. But for difficult for us, my lord, not
I tell you, because there are many other litigants who are also suffering a lot.
This is a time-consuming matter.
This is a matter which really comes in or argues in this fashion. I think at least 3 days are required for this. Mr. Sanyal says, I will not take 1 hour, but I believe.
No, my lord.
No, I'm never saying.
This is a matter which will, my lord, the question is of seminal importance. I tell your lordship, this is a question of seminal importance, so far as this state is concerned. This is unique, because my lord, your lordship would consider all the Supreme Court judgments which all the parties would be citing. My lord, then your lordship may be required to, may not be required to distinguish Nirav Kumar in the facts of may be required to, may not be required.
Nirav Kumar is not the first in case of state of Gujarat. There are other cases.
Yes, my lord. My lord, kindly, my lord, kindly hear us, my lord. Well, we are ready, my lord, so far as we are.
We are also ready, but at the expense of the other bona fide litigants of the state.
Problem with us, my lord, is
there are many who are not getting a single penny.
I tell you, lordship, what happens. My lord, I tell you, lordship, what happens on the days when this matter is listed.
There are many where the interim order is also required immediately.
The matter in some other court. All the candidates come and practically drag me to this court. This is the problem I am facing personally. Ask any of my learned friend, my lord. I understand, my lord.
No, no, we
Their
definitely-
angst is also.
They are
to
the
be understood.
aspirants. No,
Their angst is also.
absolutely,
Their
because
angst is also to be
we
appreciated.
respect their sentiments, we respect their agony. But it's a time consuming because you will take whole of the,
Yes.
and there are many entry models every day morning. They
I
mention
cannot
for entry
complete today.
models.
Well, it's impossible for me to complete today. না এখনই যাবেন না স্যার দাঁড়ান এক সেকেন্ড
So why don't we fix it on Saturday?
this Saturday? No. না তুমি কি করে
Whole day from 10:30
Mr.
till
Sandal-
4:30, no problem.
আমি জানি না তুমি যা ডিসাইড করবে আমি তার উপর মানে হি ইজ সিনিয়র টু মি ইন মাই প্রফেশন হি হোয়াট এভার হি উইল ডিসাইড আই উইল ফলো হোয়াট এভার হি উইল ডিসাইড আই উইল ফলো মানে that Mr. Sannal knows me personally that I will not.
It's not it's only a fifth. Friday is a holiday.
Saturday, this Saturday, kindly do not, my lord. Mr. Sannal will be out of station. He will.
Go to my daughter. Kindly do not miss.
Whatever date suits your lordship, my lord.
No, it's every day that suits me. I don't mind you continue with this. Other lawyers who are there, if they mention the matter, that's the most embarrassing part on that I can't accommodate because of this matter.
My lord, would your lordship give us 1 day time? Your lordship may adjourn the matter today. Would your lordship give us 1 day time? Let us consult the bar, my lord. Kindly allow us that. My lord, Mr. Sannal will consult.
There's no necessity. In other matters, they appeared. The bar was not consulted. I think the bar would be very happy if the work is done.
As a special case, your losses can do it.
Is always, all matters are not fixed in this way, but this is what is of a great importance.
It's a great important
An
matter.
interesting,
Interesting issue.
the legal issue is there, which really requires a very patient hearing.
Then your losses next Saturday.
Saturday week. But my lord, we will not be able to complete before.
But that
vacation.
is, but that
anyway,
is,
you will not be able to complete before vacation.
That
It will
I
take
should.
time.
It will take time, my lord. My lord, I will take 2 or 3 hours.
no, that's why I say Saturday would be the best.
Let us start on a Saturday week.
Saturday week. All right. a week before vacation.
You say that you are always being dragged, or you are really.
Yes, that's a fact. That's a fact, my lord.
May I use the very other word, lighter, hijacked from the
Hijacked
other
from-
courts, and then you are.
My lord, kindly, we will do on Saturday week. On Saturday.
Saturday week.
Saturday week. Not this Saturday, my lord, Saturday week.
Saturday week. I will tarikh করছি।
13 তারিখ করছি। আবার 13 তারিখ।
Before the 13, then only one Saturday before vacation.
এইটাই last Saturday।
13.
13th একটা Saturday তোমার।
তারপর তো ভ্যাকেশন
13th. Fixing this matter on 13th, and from morning.
বাকি কেউ জিজ্ঞাসা করছে
মানে Mr. Mukherjee is also here.
No, he has to be there.
He has to be there.
But at the same point, I added that we have also referred the matter to the police constable. Same interpretation of self-constitutional tracks.
Then why we are hearing it?
Yes, but in the similar point.
My lord, I tell you, lordship, my lord, so far as my client is concerned, my lord, then this matter may not.
No, Mr. Mukherjee is saying that the similar point.
Concession and reservation point is before the Honorable Chief Justice. also. In
So,
police matter.
so when
But
the
other
honorable.
points are different. But that's the basic point.
This is the basic point, just we are not sharing this matter. That
But
is
your
the-
losses can go on this hearing.
That was.
But this is your losses, some difference.
And
are there.
My
I
lord,
he
so
said
far
that
as-
I have already referred some of the matters there.
That's wrong. That's wrong. Your lawsuits has referred the matter because of the Supreme Court judgment that there should not be a stay in the police appointment. There should be immediate police appointment. That's why, my lord, there was a appeal and that was remanded before the Honorable Chief Justice. And the other appointment matters, that's why your losses referred.
So this is also the same matter.
No, this is not the same. It's not the point of the same.
I am not in that matter. I am not in a position to come.
The other one.
আমি
There is
যেখানে
a resolution of the PSC. There is a resolution. Malab, your losses may interpret either way. That's the point asking. but no such resolution or documents involved in the police matter. These are totally different. But ultimate point is whether having availed of the benefit can go to the answer.
If that is the matter which is pending before this Chief Justice in PIL, then will it be advisable that the two consistent
That's not a PI. Our is the tribunal. And that is being hard separate.
and this has gone to the Honorable Chief Justice.
Which one?
ওইটা পুলিশ
So I think the same point is involved. Then why we will take up that matter? Why we will take up that matter?
No, I tell you, losses, this is not.
It will be an inconsistent or contradictory view. By this time, the Honorable Chief Justice may take one view. We may take.
You are fixed on 13th June.
No.
13th June. That matter is.
Man, I am not there in that matter. I am not in a position to comment.
No, this was not told to us. This was not told to us.
I am not there in that matter. Man, I am not in a position to comment at all. Man, Mr. Shant,
No, we are ready to hear. We are not shying away, but just the judicial discipline, what I feel is.
I tell you, losses, there is nothing has been hard as yet on me.
But whatever, when the matter has, when the
point before your losses go one question, ultimate point before the Honorable Chief Justice are the same. But you losses can hear it out.
Man, so far as Public Service Commission is concerned, well, I say it on, this is my statement before your Lordship. Well, we are ready to do the matter before your Lordship. But well, I do not know about that matter. Well, I am not in a position to comment.
Your losses, can you see your lordship order when the matter was referred to?
Give it to me.
That was in view of the Supreme Court order that there should not be any stay. But ultimately, you are not right in making that submission because that's an order from the tribunal.
That is also.
না আমি জানি না তো আমি এটা জানি না আমি কেন বলতে যাবো আমি যেটা জানি না আমি কমেন্ট করতে যাবো না আমি নট ইন আ পজিশন টু কমেন্ট আমি কি করে করবো আর সেটা নিয়ে নিচ্ছি আমি এক্ষুনি
And this was the order of the honorable.
অ্যাকশন দেখবো অর্ডার
So tell you one.
না জাস্টি আমাদের ডিসিশন নিয়েছে ওরা অ্যাকশন দেবে
সুপ্রিম কোর্ট তারপর ওটাকে বলবে প্রত্যেক হাইকোর্টে তখন এটা হয়েছে ওখানে যেহেতু পুলিশ অ্যাডমিনিস্ট্রেশন নিয়ে এটা ছিল আমরা বলেছিলাম যে রিপিটিশন দিয়ে হয়ে গেছে
আমি জানি না এটা
চিফের কাছে ছিল পাসিং ইন because it was in relation to a there were several directions passed by the state. এটা তো হচ্ছে
And that was the judgment of the honorable.
Yes,
that was the judgment of the honorable Supreme Court. That is WST number 9 of 2020. That was police force report.
Police forces. Yeah, the searcher at some point. Monitoring the state of this court continuing.
ওখানে ও হ্যাঁ 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 জানি 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 এখন এক একটা জায়গায়
of the state by the Supreme Court registry to the concerned the Chief Justice to give
Personally, there is no impediment for clarifying the law.
But the point, as you say, is
Factual background is different, but ultimate point is the same. I admit that.
But that if they got age relaxations at the time of death, further they would be considered as a unfair candidate or not. That is the point to be decided that police.
না ওখানেও কি এজ রিল্যাক্সেশন?
Age relaxation.
ওখানেও এজ
Age
রিল্যাক্সেশন?
relaxation.
ও
And same standard of exemption.
One of the direction you have seen,
ইন মানিশ কুমার?
Supreme Court,
But ultimately, my lord, our appeal was. being
come
heard as
to the relief E on the next page. These were the directions sought in the writ petition under Article 32. Relief E.
Actually, my lord, our matter should not be tagged with that matter. But because of the submission of Mr. Mukherjee and I was not aware of this. Otherwise, this should not be tagged.
Anyhow, you come on 13th.
After
হ্যাঁ তোমার হলো না।
Both all the councils appearing for the respective parties uniformly submit that the matter
আমরা কি জানি?
would consume a considerable time as various documents
আরেকবার ওদের সাথে বসতে
and
এখন আমরা রেডি আছি।
various documents are required to be collated and placed before this court. In arriving at the decision on a seminal point.
আমার মক্কেল দেবে না,
Not in the instrument.
তোমার মক্কেল দিতে পারে না। বলছি যে 10টা থেকে স্টার্ট করে দাও, সাথে শেষ করে দাও।
Since the instant writ petition, which since the instant writ petitions which were entertained several occasions before, but the hearing could not be concluded because of the paucity of the judicial hours. We requested the councils appearing for their respective parties to agree that the instant matter can be fixed
এখানে একটা করে বন্ধ হয়ে যাবে,
on Saturdays.
কন্টিনিউটি থাকবে, কেসটা কন্টিনিউটি না থাকলে এই কেসটা শুনানি
এটা অনেক বেটার হবে, কারণ তোমার কন্টিনিউটি থাকবে।
কন্টিনিউটি থাকবে, পরপর 3টে শনিবার শুনবেন কেসটা হয়।
Which is normally a non-functional
বাড়ি থেকে বার করে দেবে আমাকে।
day of the High Court.
তাহলে ওই মোটামুটি শেষ হয়ে যাবে।
The councils agreed in this regard and requested the matter to be fixed on May 13, 2023, to be taken up at 10:30 AM. In view of the above, let this matter be listed on 13th May 2023 to be taken up at 10:30 AM onwards. 10:30 AM. Let this order be placed. Let the file along with this order be placed before the Honorable Chief Justice for passing an appropriate order in the administrative side.
My lord, only one prayer, my lord, joint prayer, my lord. Joint prayer. Let it be Saturday, my lord. But my lord, just on reopening.
Because before reopening, your
Let it be heard in part. Let it be heard in part Saturday, just on reopening.
This is against my principle.
Why,
I
my
do
lord?
not keep any matter part.
That's okay then. But your
That is against my principle, because then this matter would stuck to me. And if there is a determination,
But
change
my lord,
of
we will be
determination,
not
at least you get
interfering.
an
But we
opportunity
will
somewhere
not,
else.
we will be not interfering with your lordship's business as it seems, because my lord, it will be on Saturday.
So
My lord, Saturday, my lord, any bench ki.
we are fixing on 13th. Do you have any problem on 13th?
My lord, I tell you, lordship, my lord, the matter may not be concluded on 13th.
So
Then the next Friday will
after vacation.
Let us start on 13th.
Oh, very good, very good.
Let
We
us
come on
start.
13th. We come on. May I take your lordship's
And all
kindly,
this,
madam?
at your order. No, yes.
May I take back the one, this, instead of that,
Take back.
I am taking back, my lord, I will give back. এনে দিয়ে দেবো।
কপি নেই স্যার, আমরা
দিয়ে
দিচ্ছি,
দেবো।
আমরা করে দিয়ে দেবো, করে
দিয়ে
দিয়ে
দেবো।
দেবো।
আমি দিয়ে দিলাম।
হ্যাঁ।
I take your losses kindly, ma'am. হ্যাঁ।
স্যার নাম
Yes.
স্যার
Call next matter immediately.
আর কিছু আছে?
হ্যাঁ হ্যাঁ একটু স্যার স্যার
Call the next matter.
এই দুইটা
আমাদের
And I am for the petition. Petition. And Lordship had this matter earlier days, that a lady claiming has a second wife, as a wife. My marriage, the petitioner before said marriage took place in 1985, and she is claiming that her marriage took place in 2010.
Who is for the other side?
Mr. Mukherjee is other side. He has.
I am for the private respondent.
Mr. Mukherjee is. That I filed an application for leave to file the writ application for this reason, my lord, because I was not made party there. And the respondents, who is the authority to sanction the pension, you also not made party. Our losses can come to yes, sir. Yes, sir.
Where are your documents?
My lord, losses can come to page first, my lord. The previous document is my son, daughter.
Yes, who is for,
I am appearing for the.
so you
Private
like to
respondent.
contest? You like to contest? We have to stay the operation of the order for the time.
One of the order itself, my lord, your lordship, I have considered the, because my lord, from the document.
Because it was says a competent order to say by passing a reasoned order upon
Yes.
following this.
That order has been passed. Person to which the order has been passed.
Where?
And it was, yes, my lord. And it was directed the both the, because there is dispute regarding the identity of the wife. So both are directed to file the success certificate from the competent court of law, establishing that this is the order.
And this is not the order of the tribunal, man.
No, no,
The
the
order of the
tribunal
tribunal
has
is the-
simply, sir, the tribunal has simply passed an
I-
order directing
Give me, my lord.
to release the admissible retirement benefits as per
To the
rule
second
by,
right, my lord.
by way of passing a speaking and reasoned order
Yes, my lord.
with follow-up action and to communicate the same within 8 weeks.
My lord.
Now the authority has said that since there is a there is a
There is a
rival contentions, rival claims, it is better that they should obtain a succession certificate.
Competent civil court.
No, that is
competent
not,
civil
my lord,
court.
first, my lord, first. Not
So-
civil court, my lord. The district magistrate is the competent and he has given.
What?
My lord, the
Succession certificate?
Yes,
District magistrate,
no, my lord. Losses can come
district
to-
magistrate succession certificate will be, he will grant.
my lord, yes, losses can see in
Then
pension
what is
matter.
the utility of Indian
In
Succession
pension
Act?
matter, in pension
to
matter,
come?
the district magistrate is giving.
District
Losses-
judge will grant a succession certificate. Sir, then the Indian Succession Act has to be repealed immediately, sir.
My lord, that is
Immediately.
separate. When I am claiming, my lord, the money, husband died money, where the money, cash money has to give in. That is even, my lord, now it is a family pension matter. The losses can come to page, my lord, the nomination in my favor. That is at page 27. 27 losses can come.
I do not think it has got anything.
My
If
lord,
you are
my lord-
aggrieved, sir, you can go and challenge this order. Now it has been communicated to
Yes, yes.
them also.
The forwarding, my lord, will find the name of the petitioner, and the bottom, my lord, it is forwarded to me.
So that has been done. So on the basis of this order,
Yes, my lord, your lordship will find from the opening sentence. আর ওই অর্ডারের কপিটা আনিস নি আর ওই অর্ডারের কপিটা যেটা সার্ভিস করেছিল পরে এই যে
My losses kindly come to photocopies of the no. My 27 my nomination. The judgment, Supreme Court said, my lord, the second wife has no claim. If any children, then they have claim. And my case was forwarded by the department. And losses kindly come. Page 47. Losses kindly come, page 47. 27, my nomination in the service book. 27 is nomination in service book.
When this order is passed, 7/2/2023, but there is no reflection of
Last question, as
this
a
order.
copy of the order sheet from the office of Srimati Shunalina Chatterjee, last second page. After
From there, I came to know there is a case.
submission of relevant documents for the course of action,
Oh, this is what is there.
submitted documents like such and such.
Then sir, you go.
Losses
You go, you have to challenge this.
I have to not challenge that, my lord, because losses can come.
Sorry.
Page 47, my lord.
Yes,
Losses
you
here.
have to challenge.
Losses 47 page. Page 47, then 27, then 47. Losses peruse it, my lord. Thereafter, my lord, losses pass it.
Yes.
Peruse it, my lord.
Yes, we perused it. Yes.
My lord, losses 27. Nomination in my favor.
The present
Then
writ
47,
petition,
my lord, case was forwarded.
we are taking here. The present writ petition is filed, seeking leave
It will
to
take time, my lord.
seeking leave to file the instant writ petition challenging the order dated 24/2/2022 passed in OA 752 of 2021 by the West Bengal Administrative Tribunal. So the writ petitioner as well as the private respondents are claiming exclusive right in respect of the estate left by the deceased government employee.
Supreme Court judgment is there, my lord.
Deceased government employee. As legally wedded wife.
Supreme Court has not said so, my lord.
Since the authorities were not taking any steps, since the authorities were not taking any decision on the claim, the private respondent moved.
I'm not private, yes.
The private respondent moved before the tribunal in OA 752 of 2021 for a direction upon the concerned authority to forthwith take a decision on the representation and declare the candidature of the private respondent as valid for compassionate appointment.
She withdrew the prayer, my lord.
The private respondent further sought for a direction upon the respondent authorities to forthwith release all monetary benefits, including gratuity, interest upon the gratuity from the date of the death till payment, family pension and other retirement benefits admissible to the deceased government employee. By an order dated 24/2/2022, the said proceeding was disposed of, directing the respondent authorities to release admissible retirement benefits as per rules by way of passing a speaking and reasoned order with follow-up action and to communicate the same within a specified time. According to the learned advocate for the writ petitioner, she being the legally wedded wife and being nominated in the service record to receive all such service benefits. And in fact, the authorities
has forwarded
proceeded the files and the papers so that she will get all such benefits, she cannot be deprived of any such right. It is further submitted that the heirship certificate has also been issued by the district magistrate,
in favor of me.
which would say that the writ petitioner is a legally wedded wife. And therefore, the authorities cannot ignore the aforesaid fact and deny the legitimate claim. In course of the hearing, the private respondent informs that pursuant to the impugned order, the authority took up the issue and sensing the complexity thereof, directed the parties to obtain a succession certificate from a competent court so that all such retirement benefits can be dispensed with. The learned advocate for the writ petitioner is very much vocal that the moment the nomination has been done, she is entitled to receive the same.
And alleged second wife has no claim.
The nomination is not a third kind of a succession recognized under the law. The law recognizes two kinds of a succession, namely intestate or testate succession. The nominee is always regarded as a custodian of the corpus, but does not. But such right is not, is custodian of the corpus and does not have an inchoate right or a vested right in respect thereof. Towards the heirs and legal representatives of the said deceased. The nomination has been.
And a Supreme Court judgment I am serving.
Yes, 1983, 2 is against you.
And it is 2000, volume 2, Supreme Court.
Correct.
Cases.
Correct.
Second wife has no.
Please read.
Second wife has no claim. That is not.
Whether my lord first wife, second wife, my lord, this has not been
We
adjudicated.
do not want. It's a case of a nomination. Kindly consider.
There's no
You're
admission on
talking
my
about
part.
nomination. I'm
and
talking about 1983, volume 2, SEC against you. It's a 3-judge bench. If I correctly remember, in case of LIC.
LIC.
Anyhow, ki bole chi? Section 39 of the LIC Act was considered.
That is separate issue, my lord. That is the who is the gate.
Ki bole chi? Huh.
And does not have an inquired right or vested right in respect thereof was the act of legal representatives of the said disease.
In absence of any express or specific provision under the statute. The nomination the concept of nomination is to ensure the disbursement of money by a nodal employer as a valid discharge. But the moment the heirs have disputed, the entitlement, there is no fetter on the part of the nodal employer to seek a document creating an entitlement on such heirs, irrespective of the fact that the nomination has already been done. Stop. We do not intend to go much deep into, we do not delve to go deep into the aforesaid aspect, as the order dated 7/2/2023 had been communicated to the writ petitioner, and therefore any observation may affect their right to challenge the said decision before the appropriate forum. Since the order has already been implemented, impugned order has already been implemented, and a further decision has been taken by the authority, wherefrom it appears that immediate threat to the invasion of the right is absent. We therefore grant leave to the respective parties to take an appropriate steps against the said decisions before the proper forum. With these observations, the writ petition is disposed of. No order is to pass.
The order we kept with the record, my lord, the order which I had.
That
It
is
is
in
order
in
we
the
kept.
in the writ application. I have annexed it.
No,
Page
no, no.
47, you see. Page 47.
My lord,
My lordship gave leave to.
no, no.
Now, where are the other councils who consumed the whole of the day?
My lord, the next matter.
There is a deadline for me to join in.
I understand this is what are indicated that if you continue like this, then there are many matters where immediate interim orders are required.
My lord, the next matter is mine, my lord.
Yes.
My lord, I will not be there on the next Monday. So I am praying, my lord, let it be placed on 15. Item 78. Item 78. No, 15.
Look at it. There is another matter which has now come. Now there are 5 matters assigned relating to the virus of section 10C of the West Bengal School Service Commission Amendment Act 2017.
No.
Look at the plight.
My lord, I was praying for the next matter, 78. My lord, let it be placed on the 15th because next Monday I will not be there, my lord.
Where are other matters? All such matters. What can be done?
No. No, my plan was for 78, Baba.
Next Monday you are not there.
And on the 15th.
After
my lord.
vacation,
No,
no,
let it be placed on the 15th, my lord.
placed after vacation. You are for the petitioner.
No, because I am going out, my lord, for my health check.
You are for the petitioner.
70,
Petitioner.
yes. কি দিচ্ছিস এগুলো? বলেছে? সুপ্রিম কোর্ট তো সব রকমই অর্ডার দিচ্ছে। হ্যাঁ হ্যাঁ সেই তো বাপের জমিদারি হবেন না?
Same thing is, sir, you'll have to appear. What can be done? All these matters have come by way of an assignment. Is after vacation, no difficulty.
Can my matter be on reversible
After vacation.
Come tomorrow, give the notice to
Only-
other side. We will be sitting for one matter. এটা দিয়ে দাও, এটা FA has come. FA টা দিয়ে দাও to be mentioned. Yes, চল।
After vacation.